And we are back, and we are back. Thank y'all for watching. Go ahead and hit that like button for Yak Gotti's, for Diamante Kendricks's three directed verdicts today. What does that mean? That means that those charges, those counts are essentially dismissed. He won't have to worry about those going to the jury. What Judge Whitaker did is she took those 3 counts, she balled them up, she threw them in the trash can, and she burned them. It's over for those. Now, Yak's not out of the woods yet. He's not out of the woods yet because there are still other charges that he has to face that will go to the jury. But his attorney, Doug Weinstein, successfully argued to have 3 of those balled up and thrown into the trash can. So that is excellent work by Doug Weinstein. Y'all don't forget, we are a paralegal school. Been around over 20 years, started in 2003. So what, going on 22 years now. We've been helping people learn about the paralegal field, get working in the paralegal field. If that's something you want to do, get in touch with us for our paralegal certificate program, www.careerparalegal.com, www.careerparalegal.com. You also, what we're going to do here, first we're going to show you the directed verdict. So we're jumping right to that part, which everybody will want to see. Then I'm going to show you the end of the day where they're coordinating how the trial is going to unfold from here. Then after that, I'm going to show you the middle part where they're haggling over all the minutiae, where they're getting into the nittiest of the gritty and the smallest of the little details. Okay, so we'll start off with directed verdict. Then we'll go to the end of the day so you can see what the schedule is going to look like. That's really important. You really want to pay attention to that. And then after that, I'll show you all the minutia that happened during the day. And one last thing, y'all, there was significant audio and video problems today. You're going to notice that I did try to correct it for you. So this is probably going to be the best feed you're going to find. But again, try to do what I could do. Okay. So without further ado, don't forget to like, comment, subscribe, and let's get into it.
First, with regard to the ruling on the motions for directed verdict. So both the state and the defense requested and have gotten a trial in this case before a jury. Is not before the court as a bench trial. So that means that this court is not the trier of fact. And the standard, as you all know, for a motion for directed verdict is not the beyond a reasonable doubt standard, that what the jury is going to be determining the facts on when the case is given to them. The standard at the stage of motion for directed verdict is that all of the evidence is to be viewed in the light that is most favorable to the prosecution, and doing it in that way, looking at it in that way, is there any evidence from which a rational trier of fact could find the essential elements of the crimes that are charged. So with regard to the motion for directed verdict on counts 1, 2, I'm trying to do these in order. Now let me just do it this way. I am denying the motion for directed verdict on all counts except I am granting a motion for directed verdict as to count 59, count 60, and count 62. I do not believe that the elements of, that even viewing in the light most favorable to the prosecution, there's evidence upon which a rational trier of fact could find the essential elements of possession of those particular items. And let me say that with regard to counts 2 and 49, again, is not a beyond a reasonable doubt standard that the court is required to employ in determining a directed verdict as to those counts. I understand the arguments, but it is up to the jury to determine credibility of witnesses, and it's up to the jury to determine what witnesses or what parts of testimony they might believe and what witnesses or parts of testimony they might not believe. So if there is evidence presented that a jury chooses to believe, which is how I have to take it in evaluating this. I have to evaluate it as though the jury is going to believe whatever is most beneficial at this point to the state's case, which means they could believe everything that Mr. Copeland or Mr. Zachary said that would support the state's case. And frankly, they can disbelieve even an expert's testimony. And so I just wanted to add a little more with regard to what my reasoning was as to those counts. So that's, y'all know now what it is that you need to be preparing for closings. And I think unless there's anything else on those matters, that we can turn to the hammering out the rest of the jury charges and sorting out the verdict form. And I appreciate that y'all seem to have been able to determine for a lot of the overt acts, which there is not any evidence of, and so obviously those will get redacted out of the indictment. Oh, let me also say with regard to those gun charges that we talked about earlier, that I am granting a directed verdict with regard to the greater of those charges on the 133. The state even admits they don't have all of the elements for that. So those will be charged as the lesser. It looks like that Martinez case provides that even over a defense objection, the state is entitled to get the lesser charge for those counts. So that's why that's kind of, I guess, a grant of a partial directed verdict as to those counts. And those were the, well, y'all know which ones they were. I don't have them right in front of me. What were they?
52, 64, and 61.
Okay, thank you. All right. So I haven't yet seen the proposed charges on the crimes that are set forth in the overt acts. So, Mr. Atkins, we did get, there were some additions or changes with regard to the state's proposed RICO instructions, but have you sent yet the crimes that are just set forth in the overt acts?
The pattern instructions, Your Honor?
Yeah.
Yes.
Okay, maybe we just missed that.
I titled it, Your Honor, proposed, I think, supplemental jury instructions.
All right. Well, Ms. Persfield will look for that. I know there are a couple of things we need to circle back on the non-RICO part of the jury instructions, but let's do the RICO part first, if you don't mind. And I keep further editing my proposed RICO jury instructions, so y'all have the latest, I'm not going to say greatest because it may not be, but the latest version of what the court is thinking about charging. So if we want to open that up and kind of start there, and then I'll listen to whatever anybody wants to suggest should be in or out or said differently. Now, Mr. Atkins, I wasn't quite sure I understood your Teal. I didn't know if you were saying, oh, the court struck through these and we think they should be included, or what exactly the Teal comments were.
Your Honor, the Teal, I tried to capture either items the state believed should come out or words that the state has. Okay,
so we maybe just, as we walk through, you just bring them up to me as we get there. All right, so if we want to all get to that document.
Mr. Floyd is going to take the lead on this part.
And Your Honor, since You just emailed us. Is it all right if I remain seated because then I can
That's fine.
screen? And are we going to go through what the state emailed to you first, or are we going to go through what you just?
What we're going to go through is what I am proposing, and then to the extent that y'all want to add or subtract or modify, y'all tell me. So I can open up as well. I've got multiple screens up here. The state's latest proposals as they modified them, and then the defenses as well. I think those are the same as they were a couple of days ago.
Okay.
So, thoughts as to whether I do the overt acts in the context of the gang, of the RICO count, or whether I just walk through, you know, here are the definitions, here's how you prove the substantive crimes, the counts in this indictment alleged against these defendants, and then after that, hey, there are also some crimes that are within the overt acts, crimes alleged within the overt acts. Here's how those are defined.
Maybe some sort of transition, like as you see in the indictment, or as you will see in the indictment, count one, RICO refers to specific overt acts, some of which are alleged crimes, and then I'm providing these definitions in regards to the overt acts list or something like that.
The question was any preference as to whether that's done right after I explain RICO or after I explain all of the substantive count crimes.
No preference.
Yeah, I'm thinking right after RICO, Your Honor.
Okay.
It makes sense to just close that gap.
Okay.
But would you include these charges in the
I'd have to.
paperwork, or
Things
just
like-
tack them on at the end as an appendix, and then you could say, look, you know?
No, everything I read is going to go out to them.
No, I want it to go out. I'm just wondering if the charges for the overt acts, if you embed it in the middle of the document right after the RICO section, or I think it may be more helpful to help them distinguish these from the acts in the count, is if you say, look in Appendix A,
Right.
and in Appendix A, you'll see how to understand the charges for the overt acts.
It's fine.
Is that okay with you?
Good idea. The state's nodding assent.
Yes, Your Honor.
Okay.
Everything we agree on.
Man, look at that. All right, so Ms. Pursfield, you noticed something else?
Yes, I'm sorry.
Better now.
We don't have in the overt acts firearm possession, because there's a number of counts that are possession of a firearm by a felon. There's also a couple of counts that are possession of a firearm by a probationer. And then we have the charges against the inmates.
I'm doing that one. The probationer one is the same, is the pattern that you use for possession.
Yes, substitute probation.
So we'll add that, but then there's several possession of a weapon by an inmate, possession of a phone by an inmate.
I'm doing that one right now.
Okay, the conspiracy for possession by a phone by an inmate, and there's, I don't know if it's in or out, but the Ryan video while incarcerated.
Which number?
Is that a
That is
crime?
Act 180.
Yeah, actually,
Is that in or out?
it's in.
Right, okay, so I need something on that.
Well, is that a crime?
Right.
I don't know.
We didn't charge it as,
If
we
it's
didn't
not-
charge the cell phone that he was using.
Okay, all right, but there are some possession of contraband by inmates.
Yeah.
charges.
Okay.
or acts, alleged acts.
So, isn't, for instance, murder is alleged as an overt act, right? If I am defining all of the crimes that are overt acts first, within the context of RICO, I'm just afraid that I don't know what I'm afraid of. It seems worrisome to me, to some degree, that then that would be where they find the definition of things that they have to substantively consider against these defendants. You know what I'm saying?
My idea was if you use the appendix for crimes not otherwise defined.
Right. I agree with that.
All right, but then the order of it, I just don't think.
I would say we would use I agree with Mr. Atkins, but I would think that we would do the appendix for the overt acts class.
I agree. That's what I'm thinking.
Well, yeah,
too.
the appendix comes at the end, so.
Right, but when we charge it, when I charge it, instead of saying, all right, now I've explained RICO to you, and now I'm going to tell you about the crimes that are overt acts. Here's how each of them is defined. I'm just going to say, I'm going to define those for you. If there are any, I'll just get to it later. And I'll do everything that's a count of the indictment. And then I'll say, whatever I'm going to say. My brain's fried at this point.
Yeah,
but
thank you. I'm just a beat
RICO
behind right
refers
now.
to certain overt acts, some of which are crimes. Some of them have already been defined for you. Others haven't. Here's the definition. Okay.
Okay.
Okay, what else?
So basically here under overt acts, this is in the RICO portion.
Doesn't it? I don't know. We'll figure it out tomorrow. You and I will figure it out tomorrow. Are you saying put that language there?
Well, that's what I'm wondering, is if this is in the RICO, I mean, not all of the
Yeah.
language, but a reference to where overt acts would be.
Well, can't you just put something in there to the effect of see Appendix A for definitions of.
Well, that's the question.
Okay, yeah. An overt act may, but does not have to be a crime in and of itself. That would be the place to say that.
Right.
Some of the overt acts alleged in this indictment
Are crimes. Are allegedly crimes?
Some of the acts alleged in this indictment, if proven, would be
Violations of criminal code or crimes.
criminal violations, would be crimes. If proven, would be crimes.
Yeah.
Are you
typing this or
I'm not typing this. Nobody's typing this. I'll type it. Some of the acts, if proven.
Are you both typing into the same document?
We can.
Would be crimes. Some of the overt, if proven, would be crimes. I'm just going to highlight that and think about that tomorrow in very Scarlett O'Hara fashion because my brain is not working anymore.
Judge,
Mhm.
Alice, when you go through the indictment, the way we alleged it, where the overt act is a crime, we've identified the statute that it violates. It's very easy.
Okay.
When you look at it, they'll know which ones.
Okay, great. I may even say that.
Of the overt acts,
Those
the subset
have
of those
a
that are
site.
crimes, those are clearly identified in the allegations, and they'll have that document. So they don't have to guess which is which. It'll say is a violation of, and then there's a statute.
All right, I may just say something like those will have a cite to a criminal code section. Okay, so I'll think about that more and come up with some language. So
Tomorrow is another day.
yeah, it may be tomorrow before that gets hashed out, but
We are working on a redacted indictment
as well.
Okay.
So we'll get that tweaked and get that over to the court and everyone as well.
okay. All right. I think that we need to get together tomorrow and look at all kinds of things again, like hopefully a final jury charge, a jury verdict, what evidence is going to go out, the redacted indictment, all of those things. Which means that closings, which I think are going to take more than a day, don't y'all? I mean, if
It's possible.
I mean, y'all said, I don't know, it seemed like the time periods y'all gave me. Once you think about the fact that people have to take bathroom breaks, that people have to eat lunch,
I rarely take a bathroom break, Your Honor.
that's 8.5 hours by y'all's estimates without any break. So that is more than a day's worth of closings. So I think that means we start closings on Friday, but we probably don't finish closings until Monday. And then I charge the jury, which I hope, I have no idea how long the charge is going to take, but I would think that the rest of the closing and the charge can be completed Monday. They get the case Tuesday.
Yeah.
Well, the end of the day Monday, but I mean, they're not going to do anything in that little amount of time unless I talk really fast while I'm charging. They have a short day on Wednesday. They have a short day on Tuesday also. Oh, wait. This is,
Maybe it won't take them very long.
God, they do. These jurors, and I mean, they are trying to live their lives. I can't remember why we have a late start next Tuesday also.
Would you
Saturday?
John, would you consider, I am very afraid of closing up.
doing all of this after Thanksgiving?
No, that's not what I'm asking. No, that's not what I'm asking.
because
That's what the state's asking.
and only because Your Honor,
If we close and they take breaks and say if we don't get a verdict back on Wednesday, you're going home talking over the Thanksgiving dinner and you're doing all of this and you hope that they don't, but you don't know what
Well,
is
I'm
going.
instructing them not to, and whether they have gotten the case or not, they're not supposed to be doing that.
I agree.
And
I agree. But we would,
I'll get back to you.
we are.
Go ahead.
I think Mr. X told me not to say anything. I'm not sure.
Okay.
Matt?
Mr. Sharp.
This is my concern about Friday.
Okay.
State judges are opening, closing on Friday morning.
Mm-hmm.
Myself and Mr. Weinstein close on Friday. Jury goes home for the weekend. Come back Monday, and then all they hear.
It's like the only thing they hear is the states.
I would like, my proposal would be, I don't think everyone's going to, I don't know this for a fact, I don't think everyone's going to take as long as we think. I would ask if we could close on Monday. Whatever we don't get done, I don't believe it would be much on Tuesday. and then we could give the jury instructions Tuesday, Wednesday, and then they could come back after the break to deliver. I just am very concerned about going for a weekend. And
Yeah, I mean, I agree. Because the other thing we can do is start the closings and have the state do their open close tomorrow afternoon. And then we finish with the closings on Friday. And then I instruct them on Monday. And they get the case on Monday.
I like the other idea better. I like the other idea better.
Which was start the closings on Monday, finish them on Tuesday, which is a late start anyway of 11 at the earliest because of a medical appointment. And then I may or may not have a chance to instruct them on Tuesday, but I could instruct them on Wednesday, but then they have all of that, but then they don't actually start deliberating until they come back from Thanksgiving.
But they would have the written jury instructions.
It's true. They would have them in writing, Your Honor. It's not like they would forget them over the Thanksgiving break.
Or we could.
Yeah, I mean, that's.
Or Your Honor could instruct them when we get back.
No one listens. They're not actually listening. I think I think people are more visual anyway. They're less likely to listen for 2 hours. The charge, that's the whole point of sending it.
I don't understand what you're saying, because
when the court charges the jury, they're blank-faced. So that's why it's always so important to send it back like you suggested and you do, because when anyone talks at you for more than 15 minutes, most people stop listening. So, not saying that they do. I know I do.
Then it would seem to be in the state's interest to not have a 5-hour closing, Your Honor.
Easy.
Okay. Yeah, I like your idea for tomorrow, Your Honor, but I don't think the state, I guess the state would not agree to that.
they don't have to agree to it. I've told y'all for the last 2 weeks, be ready on Thursday to give closings. So if that's what I decide, that's what happens when it comes down to it.
I'm just not looking to throw them under the bus, but I do like the idea for them starting tomorrow, and then we would wrap it all up Friday, or wrap up the closings Friday.
And you like that idea?
I do like that idea.
Well, only reason he likes that idea is because the jury charge won't be complete until tomorrow, and so he'll have all night to process and synthesize all the information that we'll continue to go over tomorrow.
Yeah.
Mr. Abate is not lying. It's my duty of candor. I have to tell you that.
I appreciate that, Mr. Weinstein, that you take your duty of candor seriously.
Very seriously.
All right, so closings Monday. Maybe we finish Monday. If not, then we come in late on Tuesday and finish closings, and then maybe we'll just have to see. I charge them either Tuesday and they get the case, in which case I probably just won't. I mean, are they going to deliberate for one day and then go to Thanksgiving?
I would say we could probably
Close and charge on Monday after Thanksgiving, and then they'll have.
Wait.
We can certainly not close and charge in one day.
I'm sorry, not close. I meant
you
to say
mean
charge.
Tuesday?
Charge.
No, but,
on Tuesday?
On Tuesday.
But I think they should, if we charge them on Tuesday, I think they could begin deliberations immediately thereafter, correct?
Depending on what time it is.
We have court Wednesday, correct?
I mean, we're scheduled to have court on Wednesday.
What are the hours?
No, for the whole day.
Well, then that gives them a whole day to deliberate.
I had told Mr. Matthews we could quit at 2, but Mr. Matthews is no longer in this case. Have we told the jury that? I mean, the jury would.
I don't recall I don't recall you telling the jury either way about the
Wednesday.
We had that conversation at the bench.
Yeah.
Yeah, I don't think I ever did, honestly. So I think they think they're here all day Wednesday. And so they could be here all day Wednesday.
What if when you send your message about coming Monday, let them know that we're going to have extended hours on Monday. We start at 8:30 and we'll go till 7. So all the closings get done Monday.
And just get all of the arguments. We could do that.
First thing Tuesday, do the charge.
Well, at 11 a.m. or whenever they're all here, do the charge, get it.
You could extend Tuesday to 7 o'clock since they're not getting here till 11. Or whatever time.
That's the state's suggestion, to keep them here till 7, just to make that clear.
I'm not staying here until 7 on 2 days, but. And then are you saying have them come deliberate on Wednesday and then take a long weekend and then?
Yes, Your Honor.
Okay. All right. That's what we'll do.
Thank you, Your Honor.
Okay. So I still think we all need to get together tomorrow. How about 10?
Yes.
Oh.
Unanimous agreement on
All right.
And there was much rejoicing.
All right. Thanks, everybody.
Thank you.
Is it substantive?
I mean, yeah. Yes, I think so. We're going to have to get back together on jury charges and yeah.
Hey, Your Honor, they woke up Mr. Kendrick at 2 a.m. this morning. I know you don't have control over the sheriff.
In order to get him here?
They moved him at 2 a.m. They woke him up at 2, moved him to Rice Street for whatever reason, then brought him here because I don't know all the thinking behind it, but come on. Can they please not do that? Especially we have a 10 o'clock start tomorrow. Certainly they don't need to wake him up at 2 a.m. again tonight.
I agree. I'm not the elected sheriff.
I understand that.
Doubt if the elected sheriff knows that either, frankly. But to my great and devoted deputies, can you all please get word to whomever is in charge of getting the defendants here to, if at all possible, not wake anybody at 2 a.m. to start transporting them for a 10 a.m. court hearing. Thank you. I really appreciate that.
Thank you, Your Honor.
Well, Your Honor, since we had submitted those, I can go through those and explain what our thinking was.
Okay.
And the first one is, I'm going off of...
Let me find it first, if you don't
Excuse me,
mind.
Mr. Floyd. Which document are you referring to?
I think it's something Mr. Atkins sent us. Is that right? Last
Last night. One we said last night, yes.
Can you give me just...
Yeah.
It's called Jury Instructions RICO Draft is what the reline for the email is. And then it's got an attachment.
Thank you.
I didn't want to.
No, thank you.
I think there's another one.
No, that's not RICO, that's the one that's.
I'm assuming the one you're referring to is the one. It came around 8:20 last night.
No, that's a different one.
Oh my gosh.
Talking about, no.
Which one?
There's 3 documents. The court's version of the RICO charges, the one that Mr. Atkins sent last night, that was jury and, no. Sorry. That was the jury instructions RICO draft for Mr. Atkins. And then there's also, more recently from Mr. Atkins, the additional instructions that relate to some of the overt acts.
That's correct, Ms. Bree.
Okay. All right.
And so, as I understand it, we're going to talk about the state's RICO instructions that Mr. Atkins sent last night.
Sure.
At approximately 8:20, that's the one? Okay, thank you.
That time sounds right. It certainly felt like about 8:20.
I felt like midnight.
And it's got yellow and red and teal and it's multicolored. That's the one I'm supposed to do.
It's a potpourri, Your Honor. Most of these, despite the color variations, it's pretty simple, I think. The first one that the state proposed some changes to state RICO conspiracy, and I noted that the court had said needs to be tailored to indictment language. I took that.
That was really early on.
Okay, well, but I think it was correct too, because what was there prior to any modification is just a recitation of the statutory language or something very, very close to it.
All right. So if you would do me a favor and looking at the state's proposal, do you feel like that captures everything that needs to get captured?
I think it does.
Okay.
And what we were looking to do is just remove language that is in the statute
Right.
that does not apply to this case as it's been charged and presented.
Okay, so
It just simplifies it. That's
yeah, so I mean, what I'm proposing is the state must prove that the defendant, and then list out the elements, knowingly and willfully conspired with one or more others, co-conspirators, to acquire or keep money or other personal property through a pattern of racketeering activity, and that any of the conspirators committed an overt act to further a criminal objective of the conspiracy. So I think that gets rid of all of what was not applicable from the statutory language.
I think that's correct, Your Honor.
Okay. And then, you know, a similar thing for the subsection B.
Yeah. The only we've been using the word tweak in the language that tracks subsection A.
Yeah.
3 personal property, money or other personal property. This may just be semantic. I think the statute actually says personal property, including money, which includes money, but this starts with money. The statute starts with personal property. It encompasses money. It's not a big
Yes.
deal.
Money is personal property, which is why it says money or other personal property. Okay.
And as to the elements of B, yes, I think you captured that as well.
Okay.
Your Honor,
Yes.
regarding this, I just had one issue as well. I didn't
Sure.
know if- before we moved on, are you done with?
I'm done with this, John.
Okay. Your Honor, I would ask on number six
Yep.
of the elements, since, well, I don't know, I haven't abandoned my argument, but if we're going to allow all the whole list of overt acts on the indictment to go back to the jury, I would ask.
Well, not the ones that y'all decided there's no evidence of.
Right, but the ones outside the statute of limitations, I would ask that on number 6, it's committed an overt act on or after May 10, 2017, or
True.
within the applicable statute of limitations.
True.
Yeah, the only thing I'd point out is you've got that later.
I do.
And so, I mean, I agree it has to be somewhere. The question is where.
Well, I mean, the idea with listing out the elements is when they're deliberating, they can go right to that and go, all right, here's what we need to be thinking about.
Which is why I think Mr. Schart's suggested edit is useful.
So I had written down the dates. It's like between May 10th of 2017 and May 9th of 2022.
No, it would be within 5 years of the date of the indictment.
No, but let's give them the dates.
Why not just give them the date? Why make them do math?
Yeah.
All right.
Nobody wants to do math here. We're all lawyers.
The calendar in my head wasn't functioning properly.
Yeah. I mean, the indictment, the original indictment was what? May 9th. Okay. So
if that captures that 5-year window, we have no argument.
Okay.
But the indictment doesn't. The indictment says said accused together with unindicted co-conspirators in the state of Georgia and county of Fulton. You mind if I said?
Go ahead.
On or between the 24th day of January 2013 and the 8th day of May 2022. So maybe the cutoff date should be the 8th day
So
of May.
then May, what would that be? May
8th, 2022.
No, for the beginning. May 9th, 2017.
It would be May 9th, 2017.
Actually, May 10th.
No.
I do too. May 10th. I don't think they're.
Yeah, that came out May 9th.
And May 8th. And honestly, the dates don't. And I'm saying May 9th, 2022.
Your Honor.
Yes.
The evidence demonstrates the conspiracy continuing after that. The evidence that's been admitted demonstrates the conspiracy continued after that.
So what's the law on, is it within 5 years before the indictment, or is it within 5 years before the indictment?
It's before the indictment is what the cases say. I mean, if you look at, I believe it's Conzo, that's the case. And
continuing on up until the jury gets the evidence.
Yes.
Well, I would disagree with that just because it's specifically pled in the indictment. It says, in the RICO charge, it says, for the said accused together with unindicted co-conspirators in the state of Georgia, County of Fulton, on or between 24th day of January 2013 and the 8th day of May 2020.
Yeah, and with that specific date in there, I would think that anything after the 8th day of May 2022 should not be considered.
Thoughts?
Yes, Your Honor. The fact of the matter is that we did not allege that the conspiracy ended, was terminated, or abandoned. And the jury can look to subsequent acts as evidence as well. I mean, up to and including, for example, Mr. Copeland's testimony. If the jury concludes that Mr. Copeland was lying and that was in furtherance of the conspiracy, they could consider that. The case on that is State v. Cagno, C-A-G-N-O, 978 Atlantic 2nd, 921. It's a New Jersey 2009 appellate case which involved the untruthful testimony of a witness during an actual trial. And the court looked to that and said that where that witness was part of a criminal organization and the evidence indicated that he was lying to protect the criminal organization or any of its members, that could be considered even though it ran all the way up to trial.
Do you have any idea how that case was indicted? Like what the language of that?
In truth, Your Honor, I have not seen the indictment. It would have been indicted under New Jersey law in any event. So,
right.
I mean, that is, you know, I understand your question, but I think I don't think there's any question that there is evidence presented and admitted in this case that runs past those dates.
Well, the state certainly could have elected to indict it in that type of fashion with language that's a little more open-ended. But the notice that we were given by this indictment and that they elected to put in here, we didn't pick this date, is the 8th day of May of 2022.
And additionally, beyond it being cut off by the 8th day of 2022, it's our stance that any overt act that the jury's going to consider has to be pled in the indictment. And so they don't have any overt acts extending beyond that date.
Your Honor,
Yep.
I'm sorry, but I have to disagree with Mr. Shaw. The state's not obligated to plead any overt act specifically in the indictment.
Right.
That's simply not a requirement. And therefore, the fact that there isn't one after the 8th specifically alleged, although we do in the superseding, we have the 9th there. They have notice of that. Okay.
They do.
Acts 183 and 183 through 189. The dates are given on those acts, and they are May 9th.
Yeah, Mr. Floyd is exactly right. They do have acts that are specifically listed in the indictment on May the 9th. But despite that, they still chose to put May the 8th in as the timing of the conspiracy. And it's the same way that they have overt acts that predate the statute of limitations that they've placed in there. I'm sure they have good reason for that. But you know, they could have additional things in there. So, again, they're the ones that elected to place May 8th as the end date.
If I may just jump in, I'm under the belief, and maybe I'm wrong, Your Honor has granted a directed verdict for the May 9th.
Not all of it. Some of it, but not all of it.
Those overt acts would be coming out of.
No, because Mr. Kendrick, I mean, if they determined there was a conspiracy and there were other conspirators, even if Mr. Kendrick wasn't the one guilty of any of these, somebody who might be a conspirator could have been. All right, so I don't think that most of the times dates in indictments aren't material anyway. So I would think it's between May 10th, 2017 and May 9th, 2022. And I need to, that's all of the overt acts that are pled. So you're saying overt acts that aren't pled can support the conviction,
yes,
if there is to be one, as long as they are within, 5 years after the indictment?
There's no time limit afterwards. I mean,
it's just
overt acts.
Yeah.
And I understand why the defense desires to put a box around this, but the law doesn't put a box around this in the way that they are suggesting it. In fact, you might recall, Your Honor, a few months ago we submitted a bench brief on this.
Yeah.
And we showed you cases where convictions were affirmed based on overt acts that did not appear anywhere in the indictment.
Mm-hmm.
I mean, there just has to be an overt act. Overt act is really evidence. That's really what it comes down to. So here, this evidence is in.
I just don't see how, and I understand conceptually, but how does the jury say, okay, here's the overt act that we're all agreeing was proven, but it's just something we heard in the evidence that how do we even know, how are we supposed to know what that is?
Well, as a general matter, I think, I'm trying to think of the best way to synthesize this. Again, it's evidence. They just have to determine that there was an overt act, and that it was
that they all agreed to it.
That they all agreed to it. And, I mean, there's a million aspects of evidence in here. Actually, in a case this long, a million might not really be hyperbole. that they're going to look at, but we're not going to ask them, do they find that this car was the same, this gun was the same. We don't walk them through the inventory of evidence, exhibit by exhibit, and say, did you find this persuasive or not?
Yeah.
That's not.
All right. So can y'all come up with some language that succinctly and non-confusingly says had to happen by, the earliest May 10th, 2017? That just makes it really awkward.
I just also
I don't know how to say that exactly.
I just also need to clarify that I'm not trying to put the state into a box. I mean, this is a box of the state's own construction that they've crawled inside by setting this May 8th termination date, May 8th of 2022.
Maybe I should have called it a mini house. Anyway, I understand. Okay, Your Honor, the relevance of this, as far as I've understood it, is that they are finding an overt act within 5 years of the date of the indictment, because that's necessary for limitations purposes.
Right.
That's the pertinent question. And I believe you previously had a charge that explained that. If I don't see it in these court charges, excuse me. Yeah, I don't see it exactly in those. The ones that the state had submitted, I believe there is one on it there. But the only concern I have, and it's not a huge one, is that as to item 6 on these two, you're going to be saying the same thing twice.
What do you mean?
Not a big problem.
What do you mean?
Commit an overt act, and then the date. Commit an overt act after the date that is 5 years prior to the indictment. You would say it twice there instead of once in a statute of limitations related charge. That's all.
I don't know what you mean.
I'm sorry?
I don't know what you mean.
I thought what we were talking about, and I apologize if I've lost the path here, in item 6 is committing an overt act, and the request was after a specific date. That would place the overt act within 5 years of the indictment. Okay. And I'm just suggesting you could say that once in one charge that's related to statute of limitations, or you could say it twice in each of number 6 because they're identical. Committed an overt act.
All right, where's your statute of limitations language in the state's proposed instructions?
Let me check.
Because I don't see it.
I apologize. Neither do I.
Okay. Didn't think so.
There was, I'm thinking one, I know I've seen one, I guess it wasn't in this version. But the state does not disagree that an instruction that says the jury has to find an overt act within 5 years of the indictment is appropriate. That's fine. We're not disagreeing with it. It's simply how the exact language is crafted and where you place it in this sequence.
Well, I think it's probably easy enough to say committed as number 6 to both of these, committed an overt act after May 10th, 2017.
Okay.
I would suggest, Your Honor, that, it's the law. So I think we definitely want to make the jurors aware of the law as they're judging this case, and the correct law. I keep going back, we're giving them a long list of overt acts. And as lawyers in this courtroom, we're fully acknowledging that many of them, based on the date, cannot be that overt act. And we will not be back there to explain it to them. So I think we need
we can explain it to them before we send them back then.
Well, right. And I think we need, my point is, with the jury instructions, I think we need to make that very
So we
clear.
might want to add something. Many of the overt acts
I was saying
listed occurred before.
Mr. Floyd seems to want to just say it once and make us pick. What I'm suggesting is we say commit an overt act, and then if we want to say within the applicable statute of limitations, and then
I'm not going to say that. That tells the jury nothing. I am going to say committed an overt act after May 10th, 2017, and I'm going to say it right in that list.
Okay.
Isn't that what you were asking anyway? I mean, I know you wanted a, close brackets at the end of it, but.
That is absolutely what I'm asking, but in your charges,
Mm-hmm.
I think it's important that we put it there. But
Mm-hmm.
in the court's proposed charges, you also have a separate charge about the statute of limitations for overt acts. I'm pretty sure I saw that in your.
Oh, that was
in the one that you sent a couple of days ago.
Don't look at that. Look at the one that Ms. Parsfield sent to y'all about 10 minutes ago.
The one you sent today, it's in the second to last paragraph, highlighted in yellow.
And yeah.
Unfortunately, I made my edits on the one that was.
Well, that's fine. That's fine.
Yeah, I'm trying to go back and forth.
But I agree with Mr. Sharp that it doesn't only need to be in there one time, and if your goal of the initial.
It's not going to be in there just one time. And the language that's kind of at the bottom of the court's proposed RICO instruction right now, I mean, I'm thinking that it may be that those sort of paragraph language for count one and then the 4 or 5 paragraphs after that, that's going to be after all of the instructions when, we always say, you'll have a verdict form. I think this verdict form may be one that I actually hand out to them and say, and walk them through, and then kind of say, all right, look, here's how you're going to think about this. And I am going to tell them when you're filling out the verdict form, because right now, at least, I'm thinking I'm going to have them list the overt acts that they unanimously agree to.
Yeah, I think that would be best, Your Honor.
And that I'm going to say during that part, at least one of these, to support a conviction, at least one would need to be after May 10th, 2017.
Yeah, I think that would be the best way to go, and especially because of how, even for attorneys, how complex this is.
Yeah.
That if you could walk them through that form in that fashion, that would be beneficial for all involved.
Your Honor.
Yes.
Just because this argument seems to have shifted a little bit, looking at the first page of the most recently distributed court's charges, simply adding after May 10, 2017 to number 6, each time you've got it, because you got it there twice. No objection.
Okay.
That's fine.
All right.
Getting into the details of the statute of limitations as it may fit into the verdict form, I don't think you want to do that here.
I'm not going
it
to.
Interrupts the flow of the elements.
Agreed.
And then when we get to the verdict form, I have a point about what's.
That would be great, because
I can do it now, or I can do it.
Don't do
later
it
when
now.
you want to.
Don't do it now.
Okay. All right.
All right.
Not do it now.
Next.
All right. Under conspiracy, the last sentence, it may also be inferred from any evidence.
Where are you?
Last sentence.
On the state's proposed, where are you?
Following this personal.
Okay. I don't.
Okay. The charge begins with the bold
Yes.
conspiracy.
Yes.
The second paragraph under that, which on my printout is the bottom.
Okay. Yes.
All right. In the last line, it says after the commission of the alleged offense.
Yes, that is highlighted because that was the language that was proposed by somebody, and I don't know what that's supposed to mean. So, what do y'all mean by that?
I don't know that this is what we proposed, but
I don't know where it came
may have
from.
been picked up from language in other kinds of conspiracy cases. But I think here you could say the alleged overt act as opposed to offense, because some of them are offenses and some of them aren't.
I mean, I would imagine it was the state that proposed this. I mean, we could, just to be less confusing, just say presence, companionship, and conduct.
That's fine. And then we don't have to give it the temporal reference.
So, well, I don't know that we need to say it at all, because we've already said the nature of any acts done, the relationships, which would be companionship, conduct of the alleged conspirators, which would be conduct.
And so
maybe just ditch that sentence altogether.
And stop at criminal design?
So it would read, the existence of a conspiracy may be inferred from the nature of any acts done, the relationships, interests, or conduct of the alleged conspirators, and other circumstances which may disclose a common criminal design. However, mere association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act. Moving on.
If I could have just a second.
All right.
Moving on, Your Honor.
Okay.
On the second page, overt act.
So obviously I'm not going to include in there the two sources. I just wanted to let y'all know that's where I got the definition of overt act.
I understand, and I didn't think that was going to be in there. But the modifiers open or manifest, I don't think that's necessary, and I think it tends to be confusing because they're going to be left to kind of guess at what open and manifest is. An overt act can actually be inaction.
We looked at the case law that y'all cited in support of that, and we don't read the case law to say that. It was supposedly in Pasha.
Pasha says that a single overt act is sufficient. Yes.
It doesn't say it can be a passive non-act act.
Right.
So where's that?
My main point is it doesn't say open or manifest, and I can't remember.
I'm trying to define overt act.
Right.
And there is a definition of overt act in the Bradford case, and maybe that was a conspiracy case, and that's why I cited 1648.
Right. My only point here, Your Honor, is that I have never seen that language used in a Georgia RICO conspiracy case.
Okay, well, do you have a definition of overt act? Because nobody knows what an overt act is. And to define overt act as an act in furtherance of the conspiracy doesn't define overt act. I'd love a definition.
All right, Your Honor, if we can have the opportunity to take a look at it, and we may be able to submit something that does that work. I'm just concerned about open or manifest. They aren't self-defining terms. I don't think they actually.
If they don't help, then yeah, I don't want to use them if they don't help.
I'll just, if you give us an opportunity,
sure.
We'll look, and if we can find something that we think contributes to clarity, we'll certainly send it to the court promptly.
There's the Black's Law definition.
That's actually the place I was thinking of looking. Generally, jury charges, I looked at a lot of jury charges in connection with this and other cases, and I've really not seen this kind of language open manifest. I can't say that no court has ever used it. There's so many conspiracy cases out there. I'm just saying that I don't
Well,
remember
here's
any connection with
an act that can be observed.
Okay.
I don't know that I can access blacks on here. It's probably a paywall.
I can once we've finished here, and I can check on that.
Laura, I know I've got an older blacks in Chambers. Do you mind running to get it? I doubt if they've changed the definition that much in the last few years.
You probably haven't changed it since Blackstone died.
Correct. All right. Anyway, we'll come back to that.
Okay. Also on page 2, the next thing the state had was the last line, which is just the modifying language naturally or necessarily done to further the unlawful enterprise. I think done to further the unlawful enterprise is sufficient. And I'm not sure that naturally or necessarily adds to that.
Well, naturally might not, but I think something in the way of a modifier, because it's something that should not encompass, something conspirator X does that is just this random thing that might, but is not designed to further anything. I think is and we didn't make that language up. It came from some case.
Okay.
Sorry.
I understand. If it was just random, it wouldn't be done to further the enterprise. That's why I think done to further the enterprise captures what's necessary. The language in the statute is to effect the objectives of the conspiracy. There's no naturally or necessarily. And
I think it might have even been from a U.S. Supreme Court case, but we'll ask Ms. Pershfield when she gets back.
There's quite a few of those.
Any weigh-in from the defense on this?
I'm sorry, Your Honor. I have 3 different versions of very similar documents.
I am so sorry.
So
I know.
It's okay. Mister, if you could tell me, I got to
read it loud if that helps.
Well,
It's the bottom of page 2 of 5, the last paragraph in a document titled Judge Draft RICO Charge that we received.
They're all titled that, unfortunately.
I'm sorry?
I think they're
all labeled that. Rev 3, maybe it should have said.
It says, when people conspire together in an unlawful enterprise, any act done by any of the conspirators to further the unlawful enterprise is considered to be the act of all of the conspirators. However, each conspirator is responsible for the acts of other co-conspirators only to the extent that those acts are naturally or necessarily done to further the unlawful enterprise.
I'm not sure about the need for naturally, but I believe that necessarily is an important word there.
I'm going to disagree with my colleague. I think it should also.
We'll figure out the source of that language and come back to that as well.
May I go? I'm just going to try to jump in sequentially.
Okay.
So we can just go down this.
Yes, that works.
If I could go to the paragraph above that. No. Okay. 3 paragraphs above it.
To be an enterprise?
Here.
What's it say?
Here, the specific enterprise the state alleges is Young Sod.
Oh, yeah.
I'm going to ask Your Honor to consider just taking that out. We're defining enterprise. I don't think we need to make specific reference to the state's allegations.
Fine with me. I mean, they can read it in the indictment.
They can read it in the indictment and we can argue it.
Okay, it's gone.
And then I'm going to object to, there's a paragraph, 2 paragraphs down from that, in determining whether an enterprise existed.
Yes.
I don't think we need anything after the racketeering activity, comma. I think it can say, in determining whether an enterprise exists, you may consider any evidence of a pattern of interrelated racketeering activity. Period. That's it. I don't think we need it, and such evidence may be sufficient for you to.
Yeah, that came from, I don't know.
Came from Turquette versus United States and Boyle versus United States. Straight out of Supreme Court language, and it's out of Martin versus State, which is Georgia Court of Appeals adopting Turquette.
Yeah, it is confusing though.
Well,
I mean, it's like almost saying the same thing twice. I think the first time it's saying consider it, and then the second time it's saying it could be enough.
Yeah, I think you to simplify it, if that's the objective, we might just say, determining whether an enterprise existed, you may consider any evidence of racketeering activity. Just stop there.
Oh no, it needs to say a pattern of interrelated racketeering.
Well, it doesn't need to say a pattern and interrelated, so I can just say a pattern of racketeering activity, because when we defined it, it has to be interrelated.
Well, then if that's the case, could we leave in interrelated and get rid of pattern? If you only want one of those words, I prefer interrelated.
I'm fine with both of them.
Well, I am too, and that's my preference.
This is the concern I have, Your Honor, is we're drifting into the elements of 1614(4)(b) and not C, because the state technically doesn't have to prove a pattern.
Well, it's not saying you do. It's saying you can consider any evidence that there might be.
I see. All right. Fair enough.
Okay. In determining whether an enterprise existed, you may consider any evidence of a pattern of a pattern of racketeering activity.
I think just a pattern of racketeering activity. You're going to define that term elsewhere.
All right. We've got the Black's Law Dictionary now.
Drumroll.
The first one is not applicable. Number 1, an act that indicates an intent to kill or seriously harm another person and thus gives a person a justification to use self-defense. That one is not applicable. Number 2, an outward act, however innocent in itself, done in furtherance of a conspiracy, treason, or criminal attempt. So an outward act, I mean, it's okay. See actus reus, also termed positive act.
Outward act might
I think outward
work.
Is closer. Positive is easily misconstrued.
Yeah.
Positive is confusing.
I mean, I think the word manifest was like, it's something that's actually done. But whether that's a helpful word for the jury is another story. Let me just pull up Bradford real fast. All right, so this is Bradford v. State, Supreme Court, 285 Georgia 1 from 2009. An overt act is one commonly understood to be, quote, open, quote, manifest, or, quote, public, and that is citing Black's Law Dictionary. I think that's just the definition of, I don't know, it's a different Black's Law Dictionary than I have right now, but open, manifest, or public from Black's Law Dictionary, 1990. Mine's probably newer than that.
Yeah, the most recent one is...
Mine's not the most recent one. It's probably from law school, but...
All right. It's the best one.
It's the 7th edition, the one that I have in front of me right now.
I think we may have agreement that outward does the job. I think the fewer words that are used here, the better.
I think manifest can be confusing to a non-lawyer. So I'm okay with outward. Unless Max disagrees with me again.
I don't know what manifest means.
So outward, yeah, outward is good.
Outward. Okay. Means an outward act. Made in furtherance of a conspiracy. Okay. Thank you all for your help on that.
I don't know if we made it any better, Your Honor.
All right. Now back to the naturally and necessarily. Ms. Pursfield, do you remember what case that language came from? The under enterprise, each conspirator is responsible for the acts of other conspirators only to the extent that those acts are naturally and necessarily done to further the unlawful enterprise. Okay, we'll get back to y'all. Mr. Floyd, it's from the jury instructions from the APS case, which you touted to be the standard by which we should all be measured.
I think I did.
I think we're gonna.
Things have evolved a bit since then.
I think we'll be leaving that in there.
All right.
Thank you, Ms. Pursfield.
My plan is to not die on that hill. On page 3, Your Honor, definition of racketeering activity, the first line. I don't think or soliciting someone else.
Yeah, that's why it's highlighted. So that was where the teal stuff got confusing. I didn't know whether the state wanted that in or out.
I think we can take it out.
So
What we were trying to do is simplify it by not having you instruct on things that aren't.
Well, I don't believe there's any allegation or any evidence of solicitation of someone else.
Yeah, I don't either. Okay, so that would then just read, means committing or attempting to commit any of these crimes in the list. All right. Under the list, I think the states had use of an item with an altered identification mark. Do we have evidence of that?
Yes, Your Honor. It was the Trontavious Stevens had a firearm with a scratched off serial number.
Okay.
That I think that evidence came in through an officer testifying about it.
I thought so. I just wanted to circle back on that one. And then all of your other teal things, again, I didn't know whether that meant take these out, leave these in.
I apologize, Your Honor, for the teal confusion, but my intent was to, well,
let me ask you this. If you look at the list as it exists in this draft, does that cover?
It does, Your Honor, and I actually, the burglary,
right.
We do not need that. There was an allegation of a burglary on an overt act that we did not present evidence
All
of.
right, we'll take that one out.
What about use of an item with an altered identity?
Yeah, we just talked about that one.
Okay, I'm sorry.
And Mr. Adkins is right. There was some evidence of that introduced.
Okay.
The possession or the use of?
The reason we put let me explain that changer. Okay, sorry. Is that some of the drug-related offenses are broader than mere possession or use. And so we put possession or use in there because that's possession and possession of with intent to distribute. That's what's charged.
Where are we talking about?
We are in the list of crimes, the last two.
Okay. Possession of marijuana with intent to distribute and possession of marijuana?
Right.
Okay.
And I think we meant to make this modification with related controlled substances. It may not have gotten in there, but the same thing. Possession of controlled substances with intent to distribute.
Okay, so right now it's violation of the Georgia Controlled Substances Act. Do we want to? Article 2, and I assume that both codeine and cocaine are within Article 2 of.
Yes,
okay.
Cocaine's a Schedule 2, codeine's a Schedule 2 or 3, by memory.
I don't know off the top of my head.
Yeah.
So then it would be what? Possession of codeine with intent to distribute is what was charged, right?
Yes, I believe so. I mean, the language about Article 2, that comes from the actual language of the statute.
Right.
That's written for lawyers, that's not.
Right, no, I agree.
Yeah.
Okay, possession of codeine with intent to distribute, possession of marijuana with intent to distribute.
Now we have
possession of cocaine and possession of marijuana. Okay. And then I still need, we're going to have the definition of murder anyway, and of we won't have I still need the definitions for all of these, the pattern language definitions.
Mr. Atkins, can you submit that?
Yes, Your Honor.
Okay, all right.
I'm not the Your Honor.
Okay, moving on to pattern of racketeering activity.
Your Honor, one
Yep.
other thing.
Sorry.
Based on your ruling, possession of marijuana could come out, your directed verdict argument, directed verdict ruling.
Nope.
No, because there's code.
Still over. Sorry, my mistake.
I'm sure the
I agree
defense
with
would be
Mr.
happy
Floyd.
to have it out.
I agree with
but-
Mr. Floyd. They can come out.
Yep. I think he misspoke on that.
Do the current charges on the table have this second paragraph with about the threats?
Where are you?
I'm looking at.
Is it under racketeering activity or something else?
Well, I mean, Judge. Right, under we have racketeering activity, and we define it, and then we have a second racketeering activity.
Right.
Also means any act or threat.
Okay, I don't know. Do we have a threat that involves murder, robbery, theft, receiving stolen property, obstruction of justice, or dealing in narcotic or dangerous drugs?
We're going to bring them homicide. Yes, for the caption of one of the photos. Yes, we do have. We have threats and we have acts.
Okay.
So, I mean, the any act or threat involving language comes directly out of the statute.
Okay, but we don't have a threat of robbery, theft. I don't even know what a threat of dealing in narcotics or dangerous drugs would be.
By God, I'm going to deal in narcotics.
We don't have a threat of obstruction of the officer. I don't know what a threat of receiving stolen property would be. So why don't we just say, I would suggest we just take that threat paragraph out and we could just put murder or threat of murder.
Well, and then you would have what? Any act involving for the
Any act that involves murder, threat of murder, robbery, theft, etc., etc.
I think that could do it, yes.
Okay. Thank you.
Great with that. Thank you.
Okay. I'm actually changing it online. What else? So that takes us to pattern of racketeering activity, although we definitely need the definition of the underlying crimes somewhere.
Your Honor, going back just a second.
Okay.
On the reference to controlled substances on page 3, the two specific drugs would be cocaine and codeine, possession with intent to distribute.
Okay, so what I've done is just like we listed the specific other things, I've got possession of codeine with intent to distribute, possession of marijuana with intent to distribute, possession of cocaine, possession of marijuana. Does that work? Okay.
All right, thank you. All right, we did not, I don't think we tealed up page 4, which would take us to page 5.
All right, are there any issues for the defense on pattern of racketeering activity?
Yes.
Okay. And I've even got an issue on what I list as my element number 3. When it's only a conspiracy, there don't have to have been racketeering acts achieved. There might be, but there don't have to be. And so how do we deal with they've got to be within 4 years of each other?
I don't think it's relevant here because the question is the contemplated objective, not the actual way it turned out, because that would be a substantive charge. I don't think there are any that are separated by more than 4 years.
Well, I mean, y'all were just arguing we've got the murder of Donovan Thomas in 2015, and then we have the murder of Mr. Drinks in 2022, right, which is more than 4 years. And so assume that's all that they find is interrelated. Then what?
Those would be the acts that actually occurred. Okay? And in a substantive case, that would be an issue. Right? But this is where we get into this whole problem of exactly what was everybody contemplating every moment in time in a case like RICO that tends to unfold over time. And so, Shamel, specifically, let's kill Shamel Drinks might not have been in everybody's mind 4 years before. At some point, it came into.
But if they contemplated
killing opponents,
let's kill not just the leader, but the leader and everybody else we see.
Kill the cat and all the kittens as the.
Then does it even matter? Does the 4 years not matter then?
4 years does not matter in that circumstance. And there's certainly no Georgia case that says it does.
Well, are there any Georgia cases that deal with conspiracy assertions and not substantive that also talk about this
provision?
Yes. To me, this is the toughest issue there is in terms of figuring out what the actual law to charge is.
I understand the challenge, Your Honor, but again, the one thing that when you look at the cases that address conspiracy is that while there are aspects of conspiracy and substantive charges that are similar and maybe even overlapping in some respects, conspiracy is different.
Yes.
And so what this is basically importing the what ultimately happened test in here. I'll go back to the hypothetical, and I'll try to.
Well, I mean, I understand your hypotheticals. What I'm going from is the statute, which is what the law actually is, unless, further developed by case law.
I mean, the question is whether the conspiracy contemplates a pattern of racketeering activity. And if that pattern could take place within 4 years, I think that would be sufficient.
Right.
And we can't say that everything that actually happened had to fit that.
But how do we explain that?
It's not a conspiracy case anymore.
to the jury.
Now,
I mean, I don't think this needs to be mentioned to the jury, but if the court believes it does, the way to do it would be, I think, to say that they considered engaging in at least 2 acts of racketeering activity within 4 years of each other in furtherance of, and not make this a separate thing at the end.
well, so, Your Honor, on page 4 of, I think it's on both your drafts, you have an instruction, and I took liberty to propose some changes. So it might not be exactly how it is in your draft, but it says the state must prove, I added beyond a reasonable doubt.
Yeah, I'm telling them that all of this is beyond a reasonable doubt. None of the pattern charges that have been changed say that every time, so.
Okay. It says that defendant, and I took the liberty to say knowingly and willfully, agreed to join a conspiracy with the knowledge and intent.
Are we back up at, I'm trying to figure out where I should go.
Mr. Short has jumped down to below the line of asterisks where it says 4 count 1.
Okay.
But I think that this charge may be what we're essentially talking
go ahead.
about.
I just wanted to know where to.
The defendant, I added knowingly and willfully, agreed to join a conspiracy
with the knowledge and intent is knowing and willingly, I think.
Okay. Yes, Your Honor. That one or more conspirators would commit at least 2 interrelated acts of racketeering activity, and then I think we're saying within 4 years of each other, and it seems like that charge would go to under where we're just previously talking.
Okay.
So we'd move that up. It seems to me.
And, Your Honor, I was not clear from this whether the section that begins on page 4 and is under the asterisks, whether this is something you were intending to speak to the jury about in connection with a verdict form, or whether this is part of the instruction.
Yeah, I don't know. I mean, it's part of the instruction. I think it needs to get said. Whether it gets said here or whether it gets said when I get to the verdict form, I hadn't decided yet. I just think this stuff needs to get said. So I don't know the answer.
Okay. Here's my concern is that to the extent you're restating elements that have been stated before, they're being restated in different language, and that can be a source of confusion. I mean, the court, the way I was interpreting what the court did at the beginning of these instructions is you tried to make these as short and succinct and simple as you could, consistent with the language of the statute, and I understand that. But here we're kind of restating the same premise, but with different words. I don't know which set of words the jury's going to follow. That's my
I mean, as long as they're not inconsistent words, it doesn't matter. If they just further flesh something out, that's fine. So if you think they're inconsistent, point that out to me when we get there, preferably. But I don't think more words is worse. Frankly, most of this language is from some version of what the state wanted at some point. But I mean, I was kind of thinking it would be when we're talking about the verdict form, but yeah, I definitely don't want to be inconsistent. That would be bad and confusing. Don't want to confuse, want to clarify. Okay, so within 4 years of each other. So back to pattern of racketeering activity. I'm back up at page 3, defining pattern of racketeering activity. Okay, but see, hang on. So we're defining pattern of racketeering activity, you need the concept that they have to be within 4 years of each other. And then they're not being found guilty of engaging in a pattern of racketeering activity if what they're supposed to be determining is, did they conspire to engage in a pattern of racketeering activity? But the jury still needs to understand what a pattern of racketeering activity is. So how about pattern of racketeering activity means 1, engaging in at least 2 acts of racketeering activity, 2, within 4 years of each other, 3, in furtherance of one or more interrelated incident, schemes, or transactions, and then explain what interrelated is.
I didn't mean to speak over you. I think that is easier.
Okay.
It flows better.
Yeah.
It actually flows better than
it does.
statutory language.
Yeah. Okay. All right. I think that's what we'll do then. So where does anybody have?
This is not in the Teal edits, but we're doing this quickly, and sometimes as I'm reading it through, I recognize this is not the biggest deal in the world, but I think interrelated might be easier if you said interrelated here means acts that have, and then you pick up that same or similar, because interrelated modifies acts.
Okay. Yeah, that is definitely clearer.
With regard to criminal objectives...
Hang on.
Sorry.
Interrelated here means acts that have.
Yes.
The same or similar, blah, 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 or that are otherwise interrelated. Is that what you're proposing?
It is.
Okay. I think that works. All right, next.
Here, as far as criminal objectives, you pointed out that, as expressed in the indictment, there were some things that were not illegal, wouldn't automatically be illegal in some of the 5 categories that we listed, and you taken 3 of them here.
Yeah.
We do not object to that.
Okay.
I think this encompasses also everything that was illegal in the other 2 categories, and therefore it's easier for them to remember 3 than it is to remember 5.
Okay.
Does the court plan to give them a copy of the instructions?
Oh, yeah. I always do, even in a one-day burglary case. Yeah. Not that we ever try those, but yes.
Yes. Okay.
There's no reason it has to be a test of memory. I'm not, however, going to tell them that until after I give them the instructions because I want them to pay attention. Okay. All right, so now down to the kind of paragraphy language. My thought was that that would come not within these instructions, but at the very end when we get to the verdict form. But we still need to kind of walk through them and make sure that there's not anything that's incorrect or inconsistent that I'm saying. And Mr. Shart, you had mentioned, does the first one need to say, knowingly and willfully? And maybe I was thinking, and with the knowledge and intent would be the same, but it probably is safer to just say knowingly and willfully.
I think you're right.
Okay.
Is that additionally or in lieu of?
Well,
I'm sorry, what's the proposed revision?
for count 1, the state must prove that the defendant knowingly and willfully agreed to join a conspiracy. And then I think it would maybe just say with the intent that one or more conspirators, himself and or a co-conspirator, would commit at least 2 interrelated acts of racketeering activity within 4 years of each other to either get or keep money or other property or participate in the enterprise.
Okay, I don't object to that language, Your Honor. Thank you.
My only concern here, Your Honor, is that I don't know that we need a second statement of intent here. Knowingly agree to join a conspiracy.
I mean, if I don't say what the conspiracy is down here, I mean, we could join a conspiracy to, you know,
I'm sorry.
do all sorts of things that wouldn't be RICO.
I understand. I think you're expecting me to say something I wasn't about to say.
Okay, sorry.
No, it's all right. I agreed to join a conspiracy, I think understanding.
Oh, instead of with the intent?
Yes.
Yeah, understanding is much better.
Or maybe
Thank
with
you.
the understanding that. Either way. That way we're not giving them two intent standards in the same.
Understanding works.
All right. With that change, I don't think there's anything incorrect in that, and I don't think it's really inconsistent with what you said before.
Okay.
It's kind of a restatement. My concern is that we're getting the following paragraphs get into, I think, them determining, walking through the indictment and determining, are we unanimous on this one, are you unanimous on this one, etc., as opposed to what we were discussing yesterday, which is just telling them, you have to be unanimous that there was an overt act, you have to be unanimous on which one it was. And you'll be telling them that it has to have come after a certain day. So that covers everything. This is frankly part of my worry here, is that we get a jury who goes in with a very, very long form, they get tired, they go through, they check off a few, and then they say, well, that's good enough, she said we only needed one. And this only works if they go through the entire thing.
I mean, I'm not listing all of them on the verdict form, if that's what you mean.
Then I misunderstood. I was afraid that that's what it...
So what I was thinking about doing was saying, like, you know, I don't know yet, but defendant X did not join whatever this conspiracy is. If it's did not, that's the end of count one. If it's did, then potentially these are the interrelated types or acts of racketeering activity, or this is the pattern of racketeering activity, and have them list it.
But then now we've turned it into a substantive case, not a conspiracy case. That's my concern.
No, but
This is the pattern that they agreed to. You must then determine which interrelated types or acts of racketeering activity the defendant agreed would be committed.
Well, I don't...
They agreed that they would murder everybody. Or whatever they might come up with.
All right. I see... I think I understand what you're is looking at. Problem is types or acts. I mean, are you contemplating that they basically have a menu and they check it off?
No.
And the menu is acts of violence, narcotics, property crimes. I mean that.
I mean, I was going to get input from y'all. I don't know.
Well, that might work. I mean, my concern when I read this was I thought we were back to the point where we were looking at a list that just tracked every overt act in the indictment, and I could see a lot of reasons why that could cause problems.
So it could either be you must unanimously determine which interrelated types or acts, that one's still up for debate, of racketeering activity the defendant agreed would be committed, and then have them listed, or that interrelated types of racketeering activity would the defendant
I think all they have to decide is that they contemplated committing interrelated acts of racketeering activity.
Well, they agreed to, not they contemplated it. You could contemplate it and reject it.
Fair enough. Okay. But that's really the question before the jury is, did the agreement contemplate what would ultimately have become a substantive violation? I'm very concerned about using the word acts because you can see how they could get all hung up on that. And that's not really what the conspiracy law requires the jury to determine is the specific acts. That's what we talked about yesterday. The federal case I cited to you, they all say they don't have to determine which specific acts were contemplated, only the types.
But even those federal cases say that the jury has to be unanimous on the types of acts that were committed. You'd agree with that, correct?
Whatever the jury's deciding, they have to be unanimous. I agree with that.
And unanimous on the types of acts.
Don't talk to each other. Got to talk through me. That's just how it works in court. You know that. I know you didn't mean anything by it, but it sometimes devolves. I don't think it would with this particular crowd we have right now. But
anyway, Your Honor,
yes.
I believe that the federal cases that Mr. Floyd cites would require the jury to be unanimous in the types of racketeering activity, and I think it would be necessary for them to indicate which are the types on their verdict form.
I don't think it's required.
Well, shall we say helpful? I'm trying to also contemplate if there is, as Mr. Steele might say, God forbid, a guilty verdict in this case, and an appellate court is reviewing, I think without some tiny level of, I even hesitate to call this detail because it's so high level, but some guidance on the basis for the jury's verdict, that it would be difficult to review. And also we would want to ensure that they are unanimous on the type. So if they indicate the type, that would ensure that.
But here's my issue with type. I mean, so let's say they don't decide, or the jury doesn't think, oh, they decided they would murder every op. Let's say they decided, we're just going to hassle Lucci in any way possible. So we're going to steal things from Lucci. We're going to stab Lucci's mama. We're going to do X, Y, and Z. Those are different types of racketeering activity with the same victim. So it doesn't have to be the same type. And
that's correct.
So that's the wrong word to say.
And it's the one that crept into the case law, but I think
it's wrong. And I'm sorry, y'all, I'm kind of like thinking through this as we do this because I've never done a RICO case before as a judge.
And I've never done one that didn't have a new issue pop up that I'd never thought of before.
But
as Mr. Floyd says, that is the language, as unfortunate as it may be.
Well, I don't care if language is in a case. If it's wrong as law, I'm not going to use it.
So, Your Honor, to follow up on the point you just made, in this case, what we are really talking about with this enterprise, with this criminal street gang, is an open-ended conspiracy because they're going to do what they decide to do. And once you're in, you're basically agreeing that you're going to do what that enterprise is going to do. As long as these are things that such an organization might accomplish when you sign up for it. And this is what, when you look at the older U.S. Supreme Court cases, the one that sort of states the bedrock principles, like Pinkerton, for example, basically says, if you sign up in a criminal endeavor, you're on the hook for whatever follows from that. The solution to that is not to sign up for it, is not to become joined into it. And in a gang like this, an organization like this, sort of one of the fundamental tenets is acts of violence and threats of violence against those you perceive as your opposition or competition. You know, that's the path. You know, the real question is, are you agreeing to join in an organization that does those things?
But it's
and that you or somebody in that organization would do them.
Well, right. Yes, but that's my point.
Well, I mean, that's the rub.
That's within the contemplation. I mean, when you're joining up, those things have already happened. You already know this is what this organization does. It's not like you joined the Boy Scouts and you found out that they're engaged in acts of terrorism. It's like joining a terrorist organization and finding out they're engaged in acts of terrorism. But I mean, I think this language that we have here is getting at the point, which is, do they contemplate interrelated acts of racketeering activity will occur?
And we do.
And I guess we've already said it up above. If we're not going to say what was it, then we've said the state must prove the defendant knowingly and willfully agreed to join a conspiracy, understanding that one of them would commit at least 2 interrelated acts of racketeering activity within 4 years of each other to do one of these 2 purposes.
And in Georgia law, with the statutory definition, we pick up the same types in there. I mean, it's kind of baked into the definition that you've already got in the instructions.
But, you know, we're in a situation where, and I understand it, where the state does not want the jury to go through and say, we find this act, we find this act, we find this act. And that's the same thing that happened in these federal cases where there was an argument you shouldn't have to find specific acts. And I think that's why the federal courts have gone to, okay, fine, you don't want us to look at these, to have the jury identify specific acts, but they do need to identify, I guess they went one level up to types of acts that occurred.
Well,
but was that a conspiracy case?
Yeah,
I mean, as long as I'm saying you have to be, I'm sorry, that you have to be unanimous that they proved all these things.
And to be,
go ahead,
Mr. I don't mean to interrupt you. To be clear, the cases that I was talking about yesterday, those aren't verdict form cases. That's where the request was that the jury be asked to fill out a form that went through every single one of them. And they said no, and the jury was instructed on types, not that the jury filled out a form on types. We don't want to, it's not I don't want us to back into giving them an essay question. That's not what we ask juries to do. Juries say yes, no. And if we kind of open it up for them to express themselves, I think we're asking for trouble. There's a good reason why we don't do that.
And again, I'm not requesting a essay from the jury. I just think that having them identify what is the type of activity that they have found, or, I mean, it's not my preferred outcome, but some form of check the box, as the state may have indicated, perhaps just some guidance more than yes or no. And I appreciate that that's what the state would prefer.
Your Honor, I have an idea. We're all thinking out loud here a little bit. What if it is contemplated the commission of 2 or more related acts of racketeering activity in furtherance of one of the criminal objectives of the conspiracy? Because that would actually tie in to something concrete that you're already doing.
Say that again.
Agreed to join a conspiracy, understanding that one or more conspirators, himself and or a co-conspirator, would commit at least 2 interrelated acts of racketeering activity to achieve one or more of the criminal objectives of the conspiracy. The reason I say that is you're telling them what those objectives are, and those objectives encompass the substantive violations.
And is that a recommendation regarding the second to last paragraph on page 4?
Yes.
Could I ask what that proposed language is again?
Memory test.
To achieve one or more of the criminal objectives of the conspiracy. Right?
Yes.
But where are you saying to put that?
Where you have 1 and 2.
Yeah.
Instead of sub 1 and 2, you just say racketeering activity to achieve one or more of the objectives of the criminal conspiracy.
Okay, so
and the reason I say that here is because those objectives contemplate the violations of A and B.
but how do I know? Does it even matter? Do I need to know which one they return?
Done because of Cotton 2.
Well, I don't know what that shorthand for, or what does Cotman 2 say?
Cotman 2 said it is sufficient to prove either or both of the A or
Mm-hmm. But I don't need to know.
Conspiracy to violate either or both of A or B.
Okay, well, I know that, but I don't need to know which one or ones they found.
No, you don't. And that was exactly the question in Cotton. And
I don't think it should be the goal of the court to make the jury's decision as opaque as possible.
Well, I'm obviously not trying to do that.
I didn't want to imply that the court was.
see, that leaves one person.
Well, I'm not allowed to directly address you, Mr. Floyd.
So, can I?
Yeah.
So we were talking about, back up to that paragraph, the second to last one, and Mr. Floyd, if you could just help me follow your train of thought, does that affect what you're proposing in this second to last paragraph? Does that affect the last paragraph on that page?
I think it removes the need for the second paragraph.
See, that's what I was concerned about, because the second paragraph still has unanimously and the interrelated types of acts. So I understand what that Mr. Floyd is trying to incorporate into the second to last paragraph, but it's still leaving certain aspects of the last paragraph out.
Well, I understand.
Is the state suggesting removing the last paragraph?
That's what I just said. I think it obviates the need for it. And remember that as we're discussing this, Your Honor, this all is coming after you have instructed the jury on overt acts. They understand what they have to find.
But they do have to unanimously find which types of interrelated racketeering activity occurred. That must be unanimous.
Well, they have to unanimously find that defendant joined the conspiracy, and then also determine what.
Right.
And Your Honor.
All right. I'm satisfied that they don't have to list out what pattern of racketeering activity they think anybody may have conspired to commit, as long as they unanimously agree that a defendant conspired to commit a pattern of interrelated racketeering activity. Is there any case law that they have to list it out if it's a conspiracy case and not substantive?
First, I'll divide my answer into two parts. Part one, Georgia, no. Part two, I'm not aware of any other jurisdiction that requires it, but certainly not in Georgia.
But, Your Honor, this is my understanding. It's not just that they have to unanimously determine that, say, Mr. Stillwell joined a conspiracy and with the intent of a pattern of racketeering activity. They have to unanimously agree on
what it is.
Right.
Mm-hmm.
Like if some of them say, "Oh, he was joined for theft," and the other.
Right. Okay.
And Your Honor, I think my suggestion contemplates this because by referring back to the criminal objectives, we stated what those are. They only have to find that it contemplated two or more acts in furtherance of one of those objectives, and these objectives refer to specific types of criminal conduct.
Mm-mm. Objectives and pattern of racketeering activity are not the same element.
I understand, but each of these says through acts of racketeering activity and then lists crimes. It doesn't just stop at objective. It says you're going to achieve this objective by committing these crimes.
So you're saying that if they find any of those, that any of it was done to further a criminal objective, that even if it was, let's take criminal objective 1, a count of murder and an act of murder and an act of a threat of violence were what was contemplated, that would necessarily be interrelated because they would have had to determine that it was in furtherance of criminal objective 1, which is preserving, enhancing, protecting, blah, 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 which is a same or similar intent or result.
With the exception of the blah, blah, blah part, you said it better than I did.
Okay.
Yeah. I mean, I think it's already captured there.
Yeah. Thoughts?
We've been moving around a lot. Could I just hear the final proposal, or what we think is the final proposal?
I don't have one yet. His, Mr. Floyd's is that in that first paragraph, that instead of saying to either 1 or 2, that it would just say within 4 years of each other to achieve a criminal objective of the conspiracy.
I understand that part, and I'm not.
I haven't gotten past that part yet, too. I'm trying to figure out, how do I am at the point where, okay, that paragraph says everybody has to agree that they agreed to commit interrelated racketeering, a pattern of racketeering activity. But if they have to unanimously agree what pattern of racketeering activity was contemplated, then I need to at least tell them that.
Is there any disagreement among the parties that they do have to unanimously agree?
I don't think so. Everybody agrees about that, right?
Unanimously agree to what?
About what pattern of racketeering activity they agreed would be committed.
And state's view of this is that if it is, they had to agree to commit this act, that act, that act. I think we've passed that. I think
that's not what they're asking about.
All right. And so when we
hang on.
Sorry.
Does the state agree that there needs to be a unanimous determination as to what pattern of activity, racketeering activity, was contemplated as being carried out, whether it ever got carried out or not?
I don't believe the statute requires that.
And
if I can just finish.
Yeah, I'm sorry.
The conspiracy has to contemplate the pattern.
Yes.
Yes. Right. Does the conspiracy have to contemplate specific crimes?
I'm sorry, that's not what I mean.
I understand. I'm just
okay.
I'm trying to walk through the hierarchy. Does the conspiracy have to contemplate specific categories of crimes? No. All it has to do is contemplate that the crimes will be related to each other.
Right.
Because that's what would form a pattern.
Okay.
But do they have to be unanimous in their determination of whether they tell us what it was or not, of what that pattern was? I'm sorry this is probably really painful for everybody, but
I don't mean to
get
interrupt.
It right.
I don't mean to interrupt anyone. I'm just looking at a case from the 10th Circuit, U.S. v. Randall. I'll give you the site in just a moment, but I'm sure the state knows it. And I'm reading where they're trying to decide what circuits to align with. Yeah. And they state further, we now join the circuits discussed above in concluding that for a charge of RICO conspiracy, and this is as the state says, a jury need only be unanimous. Well, they don't say this. A jury need only be unanimous as to the types of predicate racketeering acts that the defendant agreed to commit, not to the specific predicate acts themselves. And that's where I thought that we were in agreement with the state, that there needs to be unanimity. And I know you don't like the word types, and that's their language, not mine, Your Honor. But there needs to be unanimity, and let's call it the pattern of the predicate racketeering activity. And that's the 10th Circuit, and I believe they're agreeing with a number of other circuits.
Okay, so how about if we just say, would this work? Is this correct and sufficient? You must be unanimous in your determination as to the pattern of racketeering activity the defendant agreed would be committed.
That's acceptable to Mr. Kendrick.
That's fine. Could you say one more?
Sure. You must be unanimous in your determination as to the pattern of racketeering activity the defendant agreed would be permitted.
Permitted?
Committed.
Committed.
What did I say?
Permitted.
Committed. Sorry.
Your Honor, I do have a problem with that.
Okay.
Because I think the jury is going to read that as they had to agree to commit specific acts. I know that's not what you're intending to instruct them, but I'm afraid that's what they're going to hear, and that's what the argument we're going to get.
Then we can say,
contrary to the law.
You do not have to be unanimous about specific acts, ... only You know, I mean, let's
Unanimous.
just nip it in the bud. Just tell them.
That would be great.
Only unanimous in the pattern.
That there would be a pattern.
Oh, we're so close.
And what the pattern is, really.
Right.
A specific pattern.
Yeah.
Well, the word specific just is another way to.
We
back
won't.
into
We
the
won't
same
say
problem.
specific. Unanimous. I mean, I just said it, so I'm not going to say it again. You do not have to be unanimous about specific acts. As to specific acts, what?
You do not need to be unanimous as to any individual acts.
Individual, I worry about because most people
As
think
to.
of individual, they think of a person.
Single act.
I like specific.
You do not need to be unanimous as to specific acts.
I think that's accurate.
Can you read it back as a
Sure.
whole, Your Honor?
You must be unanimous in your determination as to the pattern of racketeering activity the defendant agreed would be committed. You do not have to be unanimous as to specific acts.
Are you going to say that after, if you unanimously determine that the defendant joined such a conspiracy, and then say what you said? I'm just going by the last paragraph of page 4.
I mean, yes, I don't even know where that language went, but what did I say? After the first paragraph, then what did I say? If you...
You mean, what did you previously have
Yes.
in this document? The document originally read, the one sent to us at lunch after that paragraph. If you unanimously determine that defendant joined a such conspiracy, comma, you must then determine which interrelated types, with the S in parenthesis, or acts of racketeering activity the defendant agreed would be committed.
Okay. No, I don't think I'm going to say that anymore. I think because I am saying the state has to prove they, agreed to join a conspiracy, understanding that somebody was going to commit at least 2 interrelated acts of racketeering activity, and within 4 years of each other, to either get or keep money or participate in the enterprise or to achieve a criminal objective of the conspiracy. I think maybe then, right there, just put in parentheticals, quote, pattern of racketeering activity.
Did we lose your...
But then there was the language.
I know, I hadn't gotten to it yet. I'm sorry.
Max, did we lose your Willie?
Sorry. I think I would then just say you must be unanimous in your determination as to the pattern of activity the defendant agreed would be committed. You do not have to be unanimous as to specific acts. I don't know.
That's acceptable to Mr. Kendrick.
Okay.
Could we get a brief break at this point?
Yes.
Your Honor, obviously I'd like to look at the final words, but I think, in principle, I think you've got it.
All right. Yeah, let's take a quick break. Are we enough of us back that we can dive back in? I think I may have come up with a way to say this. So we had talked about in that kind of first paragraph whether to say that either, money or property or participate Or instead to say to further a criminal objective. Was everybody in agreement about that, or no?
Are we on page 4, Your Honor?
Yes.
Is there any way possible to throw that up on the monitor?
Yes, I could screen share. I could join Zoom and screen share.
That would be very good.
What a great idea. Okay.
Thank you.
Bless you. I think I'm in Zoom already.
Thank you, ma'am.
I'm not usually the one sharing, so. A moment, I've got it. I just have got a lot of things open, so I think it's this one. Is that the right one? Okay.
Oh, that's very helpful. Thank you.
We should have maybe been doing that the whole time. All right, so one thing I've thought about is just kind of lead in, hey, y'all, your verdict as to every count needs to be unanimous. That means you need to be unanimous in your determination that the state has proven every element of that count beyond a reasonable doubt. For count 1, here's what the state has to prove. And I've put all of it in there. I've put, and I don't know whether we want to say to achieve a criminal objective or the one or the other. We can decide. But I'm going to say all of it. You know, they have to prove all of this, and then they also have to prove, you know, an overt act. To be unanimous on this count, you must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. You do not have to be unanimous as to specific acts. You must also be unanimous as to any overt act or acts committed to further a criminal objective of the conspiracy. And then whether we want, again, the reminder that it has to be after May 10th, whatever. And then as long as they're unanimous on an overt act, do they have to list the overt act? Or do I just, I mean, it's kind of the same question again.
State's positions do not. They do need to be unanimous. There was one, and which one it was, but they don't have to list it. They only have to be unanimous as to one.
Your Honor.
Yes.
For the record, I am objecting to that you do not have to be unanimous as to specific acts.
Okay.
However, having said that, if Your Honor is going to include that, to me, the last sentence that Mr. Floyd is objecting to doesn't make a lot of sense, because we're telling them they don't have to be unanimous, and then we're telling them you should note on the verdict form.
That's what I'm asking. Do they still have to?
Right. If we're going to keep in that that you do not have to be unanimous as specific acts,
It's confusing.
As a juror, it wouldn't make much
to then say you have to be unanimous about an overt act.
Those are different acts.
I know, but are they going to know the difference? Acts of racketeering activity. Maybe that's the way to clear that up.
Okay.
Would that work better?
I think it would.
Okay.
And then I understand the state does not want the overt act on the verdict form. The defense would want or at least Mr. Kendrick would want that on the verdict form.
I would.
Which one it is?
The one that says you should note on your verdict form any overt acts in furtherance of the criminal conspiracy to which all 12 of you unanimously agree. I would like to see that on the verdict form just to ensure that they did pick one within the proper time frame.
Okay.
I'm not sure how counsel contemplate that this would actually happen. Would they list a number, or would
They'd write out, I don't know. I mean, I guess if it was an act in the listed out, they could just list the overt act number.
And I think, all right, this is why I'm asking, Your Honor, because they could also find an overt act that isn't listed out.
Well, then we'll give them a little blank for that.
I mean, I'm serious, like literally
So am
to
I.
say, and you know, do you find you can list them by number, or you can list an act, anything else that you determine is an overt act, and they can go ahead and do that. I'm trying to think of physically how this happens without them, and I'm not, to be clear, I'm not saying the state doesn't object to that. I'm just trying to figure out what it is we're talking about before I address it.
How about that?
And Your Honor, if you could scroll up toward that long paragraph in the middle of page 4, there where it says for count 1. I think that's as concise as you can possibly make it, but I'm wondering, given that it's such a complicated paragraph, if it might benefit just from a formatting perspective if you broke it up the same way you did on page 1, where the different elements are on different lines.
For one thing, we need to decide, is it going to be, are we going to say this? Or are we going to say, well, that did not help at all. Which of those two things are we going to say? There.
I'm just studying for a moment.
So the orange is what Mr. Floyd had proposed. The blue is what I had originally. And we could have the i.e. a pattern of racketeering activity. That actually doesn't go there. That goes up there. Oh, no, it doesn't, because it has to be to achieve a criminal objective of the conspiracy.
I agree with that. I think the get or keep money or other property and participate in the enterprise is wrapped up in the statement of the criminal objectives which you've given them before.
Yeah, I know you think that.
Yeah.
So thank you. What does the defense think? And actually, Mr. Floyd, do you think that this survives appellate review as giving them the correct instruction?
Your Honor, I may be right, I may be wrong, but that question is forefront in my mind in everything I'm saying.
Okay.
Yeah. And in part of that is the appellate analysis, which is the and this is why I've been referencing where you've said things in other places, you know better than I do, the jury instructions are read as a whole. And
I know.
think that encompass, given what these instructions have elsewhere, that gives me a good deal of comfort.
Your Honor, my preference is more for the original language, with the caveat that might actually go against me is that I'm just not entirely clear what participate in the enterprise means.
Yeah, me either, but that's the way the statute's written. I mean, honestly, I think it's, Mr. Floyd's might be more elegant, but the original tracks the statute, and we're less likely to commit error by tracking the language of the statute. Because if you go way up above to what the elements are, one of the elements for Part B is participate in the enterprise through a pattern of racketeering activity.
Right. Yeah. Obviously, I can't challenge that, Your Honor. I was looking at in the language that I was suggesting, I was looking at number 7, where you list the elements which references the criminal objective. So, circling back to that, I'm trying to be consistent in the language.
I mean, the other way we could say it would to join a conspiracy, understanding that. No, it's just too awkward. I'm trying to flip like the order of them, that they would get or keep money or participate in the enterprise through, but I'm not going to do it that way. All right, it's just going to stay like that.
And then drop a comma after the 2017.
Oh, yeah, you know, we're just going to have to agree to disagree on that, because I'm sorry, but I don't like to offset the year with 2 commas. Sorry.
Do you use an Oxford comma?
Oh, absolutely.
Okay, well, we can agree on that.
Okay, yeah. All right. And so then they're being told they have to be unanimous about the pattern of racketeering activity, but not specific acts of racketeering activity. They need to be unanimous that at least one overt act was committed in that time frame, and then they're going to list on the verdict form whatever acts they unanimously find. And then probably when we get to the verdict form, which we need to do soon, it's going to be, you can list them out by act number or write out what you find.
I understand, Your Honor. For the record, we do object to that last sentence. I don't think it's necessary. I understand that you disagree with me.
I don't know if it's necessary, but it's not error to do it. Is it? Okay.
That language itself, I'm not certain that it's error, Your Honor. The question is really, this is one of those devil in the details things, which is going to be exactly what that verdict form says when you embody that language.
Well, I've invited people to submit proposed verdict forms. So now that we know what the charge is going to be, I would continue to welcome that.
I understand, and we will modify our proposed verdict form because now we have a better idea of what the charge is going to be. Thank you.
And I'm sorry, it's just not an easy thing to do. Okay, so I shall stop screen sharing for now. All right, we need to circle back to a couple of items that were on the the rest of the jury charges. And I don't mind if it would be helpful to share this one as well. Was that helpful?
Very helpful. Thank you.
Is it the version that was sent last night? It should be, yes.
Yes, I haven't done anything to it. So I'm just going to scroll through unless anybody has thought of anything else to where we had noted we needed to. All right, the stipulations.
We're working on that as we speak.
Back up to the beginning and take out the counts on which a directed verdict was granted, which were counts 59, I don't know how to do that one. Laura, can you take that for action? Because I don't know how to get rid of the... Thank you. 59, 60, and 62 are out.
Yes, you're right.
And then
I don't know if that's changing on all figures. Is it? Yes, it is.
63 is not gone completely. It's just different now.
Now it's a 131 instead of a 133,
Right.
correct?
Maybe we take off the language, previous convicted of a felony, and just say possession of a firearm by a convicted felon.
Right. Right. Just ditch the previously convicted of a felony part. It would just be possession of a firearm by a convicted felon, 131. And we'll just have to explain to them something. I don't know what. All right. So then from Mr. Stillwell, 52 and 64 change. All right. Y'all are still working on the stipulations. And the stipulations, once you write them up, they can just go out with the jury? Or is that what they're going to do? I mean, in which case, if they're going out, I can just kind of generally say about these topics instead of reading them, or I can read them, whichever.
You say go.
So, I mean, normally it's like a piece of paper that's, you know, joint exhibit, whatever it is. I don't know if y'all have done any more joint exhibits, but.
So maybe we just make reference to the joint exhibit numbers.
Yeah. Okay. Have entered into, the parties have entered into stipulation about certain facts. And then.
I think there's 4 separate stipulations. So I don't know if it would make given each number.
These.
Is that correct, 4?
Bad typing, but we can fix that later. These 4 stipulations are marked as joint exhibits. We can make it pretty later. Okay. Oh.
That's why I said there might be an extra S in there.
Really bad typing. Maybe I shouldn't type while it's on the screen. And then where the parties stipulate that's in the nature of evidence. All right. Apparently down on 13140, there was a question as to whether you were going to check, Ms. Hilton, on whether any of the criminal convictions were for a crime of dishonesty or making a false statement.
And I don't think they are.
Okay, well, at this point, we're just going to say felony.
Yeah, they're not sure.
Okay. I don't know why this is highlighted.
Because I objected to
Okay.
it, but it's pattern, so I understand.
I've got a question. I mean, yes, a conspirator is an accomplice, but do we need to use both of those words here when we're saying where the witness is an accomplice? It wouldn't hurt to say or co-conspirator. Thoughts, anyone?
I don't have preference.
You don't care?
No.
I mean, I guess we're going to tell them, here's how you can, okay, I'll just leave it the way it is if nobody has any preference.
Actually, I'm sorry, Your Honor. I think it's a good idea to put or co-conspirator in there. Just to prevent confusion as to about accomplice.
Anybody care whether we say on its own or by itself?
No.
We'll just go back, and I'm not going to do this right now, but we'll just say or co-conspirator for all of those. So I'll just highlight that, and we'll go back and do that. All right.
Your Honor?
Mm-hmm.
I could be mistaken, but the only concern with the accomplice or co-conspirator is that corroboration of an accomplice instruction. With it, if it's truly a co-conspirator, it's not that same legal principle.
You're right.
I just don't. Thank you, Your Honor.
All right. And we're instructing them separately about. Sorry. All right, and the defendants have both chosen not to testify, so we now know that. Any ideas?
Well, I do.
back to here, y'all?
That's what I'm trying to figure out.
I think on the one above, we were trying to determine if that was appropriate, because did we really have a photo lineup type scenario where that would apply? I don't. And I think we were adding accomplices to the one below because we were trying to think through. There were no photo lineups type scenarios involving Mr. Kimball.
Yeah, there's no eyewitness identification really of either of these defendants.
However, there was to certain overt acts that were not these gentlemen, specifically Mr. Demise McMullen, Mr. Walter Murphy, in a shooting case.
Right.
I remember that. There's probably
Okay.
So we were trying to figure out how, if you look at 130.
Well, yeah, and it's not even just lineups. I mean, it's like the girl who was in the car that identified Ryan as the one who killed.
Right. Sorry. And so I think that probably needs to stay in there. So I think in 135.11, what we were struggling with is it's written defendants.
Yeah. Right. So.
I don't love the conspirator because it's almost, I know it's not intended this way, but it's almost like a suggestion that Ryan is a conspirator with us or Walter Murphy is a conspirator. Can we just say individual? Identify an individual? Rather than put a label on it?
Your Honor?
Yeah.
The only, I'm thinking through in terms of, if it's not in regards to a defendant, the beyond a reasonable doubt, like the germane issue of this is, you know, how a jury's going to make a pretty significant identification of the defendant in a crime.
Well, except that when we're dealing with the overt acts, even with Mr. Ryan, I mean, the overt acts still have to be proven beyond a reasonable doubt. So I don't think the standard is any different.
Now, this, I have no idea as the perpetrator of, I mean, it's not necessarily crimes that anybody's charged with if they're overt acts. As having committed.
The perpetrator of the act?
Yes.
And then not the party, right?
Correct.
Party. The perpetrator of or party to the act.
Or act/crime. Whatever.
Well, act is broader. That'll be crime.
Okay.
The act/crime?
Just
the act.
No, it doesn't matter.
Do y'all want this part at all?
Yes, please. We are not.
That a defendant show.
Is that the individual?
That another person committed any alleged offense. This part's weird because of our overt acts.
Did another person committed the alleged act? Perpetrated the alleged act?
Committed That okay with the state? Just change offense to act?
Yes, Your Honor.
Okay. And then I guess we're fine with that. I mean, if we're going to say this part, I mean, I don't know that we need to say this part at all right now.
Or maybe prove identity. The problem is these are written for the quote unquote defendant.
Yeah.
But theoretically, we are, myself and Mr. Weinstein and our clients are essentially defending not only our clients but other individuals
Right.
as well. But the burden of proof doesn't rest with us, so
Right.
it rests with the state. So I think that's an appropriate. I would just maybe I would just go back to the more inclusive individual.
But they don't have to prove a specific individual. I mean, they could prove some unindicted co-conspirator committed one of the overt acts. And so, by definition, we might not know who they are. I mean, it says up here beyond a reasonable doubt. I think that's really all we need to. It's not necessary that the defendant show that another person committed the alleged act. I think the rest of this, because it's written for something that's totally not applicable here, maybe just is confusing and also not necessary. What do you think?
The state agrees that the remaining 2 paragraphs are not needed, Your Honor, for the purposes just outlined by the court.
But it seems that the last paragraph would apply when we're speaking about indicted or unindicted co-conspirators, but we have to change the language. Actually, I don't know what to do with that.
I do.
Could we add on the end of that paragraph that remains, like the burden of proving...
The burden never shifts to the defense.
Or the burden of proving identification. The state bears the burden of proving. Yes.
What?
That's what you do in the last paragraph.
The state has the burden or bears the burden of proving identification beyond a reasonable doubt. Well, we already have it beyond a reasonable doubt, but bears the burden of proving identification.
You don't say that. Is that in the beyond a reasonable doubt?
How about just the burden of proof never shifts to the defense?
That sounds fine.
The state agrees, Your Honor.
All right. All right, I'm going to give that, so we're going to unhighlight that.
Yep, I got it.
Knowledge. So some of these come out. Yeah. I'm going to say a firearm here. Okay. Yeah, but they only have to. And same here. Right, is that right? That Gamma, that Omega.
Yes.
Your Honor, before we get too far, the only thought with the knowledge piece, of course, the court outlines the crimes provided. The state just wanted to make sure and was thinking, out of an abundance of caution for the jury to understand that, RICO is not what, this paragraph is envisioning in terms of that knowledge requirement. I mean, the court or the state was thinking through out loud if, this specific provision or instruction, of knowledge doesn't fit the RICO instructions are kind of in their own universe.
Well, that's why it doesn't. I'm sorry. But you give a set list.
Approved by the state, the honors without in order for you to convict on those counts. Does that work?
Yes, Your Honor, or this instruction is limited to these, counts or.
I think that it sufficiently says this doesn't include RICO.
Thank you, Your Honor.
Okay. Appreciate you bringing that up. Okay. All right. I'm saying this before the RICO also, but I don't think it hurts to say this one. Is this multiple ways of committing a crime only applicable to RICO?
No, Your Honor. I think when I.
All right, Laura, do you want to just delete all of the RICO stuff and drop what we just did into there?
Your Honor, in answer to your question about more than one way, that there are gang act charges here which allege more than one type of criminal street gang activity as the, I hate to use the term, but predicate or foundation for that criminal street gang violation. So we have that issue there too.
All right, so I'll just kind of say that in here in the midst of it, and then I'll say it again before I'm talking about RICO. Okay. Criminal gang activity counts 50 and 57. This one may have to be separated out for each defendant if we're listing crimes.
Well, we could put. I'm not.
Or we could
without
put.
Looking at the statute, I don't know the term of art, but I think it's criminal gang activity. And then I think we could just put the following offenses would constitute, if proven, would constitute criminal gang activity.
I have no idea where that.
But count 57 is pretty specific as to what are the actions.
I can't. What was somebody saying?
Well, you had the blanket, and it looked like you were looking I was interpreting that as you were going to add a specific offense. And I was thinking you would just put criminal gang activity as defined.
I mean,
And then we define criminal gang. It's defined, I think, above, but
it's not. Oh, yeah.
Your Honor, in that paragraph where it has criminal gang activity, I believe there needs to be possession of either marijuana with intent to distribute, because it has any criminal offense that involves violence, possession of a weapon, or use of a weapon. So there needs to be a comma, possession of marijuana with intent to distribute, because that's not defined in the first criminal gang activity. But
We don't have use of a weapon alleged, right? Oh, yes, we do. Never mind.
You have it defined below, but not in the first criminal gang activity paragraph.
So possession of marijuana
with intent to distribute.
Does it have to be with? Okay.
That's the only charge left.
Does that capture all of it?
Yes, Your Honor.
So I think. Why is that not?
I'm trying to understand, Your Honors, down here below where you have 50 and 57 lumped together.
Because that's subsection A. Subsection B, as a leader, or no, I'm sorry, to maintain or increase his status or position, which your client is not charged with.
No, but here's what I'm trying to understand, and I need the court's help. In the indictment for count 57, if you look at that count, and again, I'm not really arguing, I'm just kind of hoping for some enlightenment.
Okay.
The street gang activity under A is, the offenses are specifically listed: possession of marijuana with intent to distribute, and then the codeine and the cocaine, which have been thrown out,
right,
and then possession of firearm during commission of felony. So shouldn't, for a conviction under 57, one of those two things need to be found?
Yes, which is what the blanks would be.
Yeah, but that would apply to 57. Isn't it different for Mr. Stillwell in 51?
Yes. Yes.
Oh, I'm sorry. Okay. I
It's
understand
okay.
now.
I mean, so it may be that,
Or 50, I guess.
it may be that right here we just say criminal street gang or whatever it is, criminal gang activity, and then below what typically happens then would be, can somebody look up never mind, I've got it right in front of me. No, it's 5.3 that lists what the gang activity is, right? Yes, Mr. Sharp.
So I would suggest we just put in criminal gang activity, and then we have the definition of criminal street gang, and below that, because we're just kind of going, I'm thinking sequentially by the elements. Below that, we define what you're about to talk about right now, criminal gang activity, and then we bring that paragraph that was just above all these elements, drop it down to there.
So you're saying move the criminal gang activity paragraph down?
Down, because it's like we're giving the definition before we give the elements. So we give the elements, and then we follow with the definitions that are needed.
Where in 1615.3 is anything about drugs? Is it just because it would also be an offense of racketeering activity?
Yes.
Okay. All right. Okay, so these would both say criminal gang activity, right? This is so painful. Oh, where's paste? And then take this and move it down below. Is that what you're saying? That makes so much more sense. Thank you. Commits a crime that constitutes criminal gang activity. Well, I guess we'll do criminal street gang and then we'll do criminal gang activity. Right.
I have a feeling you only had that criminal gang activity below. Because we'll get there.
What?
I have a feeling as we scroll down, we have criminal gang activity. Right, so we can't say the same thing twice.
But
what are we doing?
Right where your cursor is, well,
yes.
Above malice murder, there's 2 paragraphs that right now are redundant.
This second paragraph begins to delete around as charged in this case.
This?
That and the paragraph above it both say the same thing in different ways.
Criminal gang activity means we don't have conspiracy to commit, right? Yes, we do. Sorry. Well, that's the definition, right? So what are y'all saying?
You're saying as charged in this case, and we kind of.
So, I mean, I think it needs, I don't think we need that, but murder, possession of marijuana, we don't have these anymore.
Okay. Your Honor.
Yes.
May I sit so I can see my screen? In count 57.
Yes.
And again, maybe I'm just not understanding this. Maybe I'm just tired. In count 57, the criminal street gang activity is alleged to be based on the commission of one of
possession of marijuana with intent to distribute and possession of a firearm.
Right. So, but not murder.
Right, but
you have murder, but the problem is the way that it's worded with 50,
which is why we may need to separate this
with
one
57.
out.
That's what I'm trying to say is murder is not included in 57 gang activity.
I understand.
Okay,
but
thank
he's
you.
not going to be. They will have the language of each count when they do guilty or not guilty, and so when they get to count 57. The gang activity alleged against your client is not going to list murder. It's just going to list possession of marijuana with intent to distribute and possession of a firearm as alleged in certain counts.
Okay.
Okay.
As long as it's clear in that form,
okay.
Then I'll be okay with that, Your Honor.
58. Okay. So we're now we don't have to define this non-pattern charge because they're not being charged with it. Nor do we have to do possession of a machine gun. We do have to do possession of a firearm. 131, though. That is a pattern, right?
Well, Your Honor, machine gun is an overt act. So if we're
Okay, well, why don't you just give me that again when you send all of the overt act things? Because I may actually. Okay, well, it's already in this or somewhere else?
It's Mr. Adkins.
Right, but is it dropped into here anywhere yet? Okay, all right. Okay, we just need to pull the pattern for 131 then and put it in whatever that document is that Mr. Adkins sent. Okay, so. Why does this say, oh. It's just any felony, right? If it's 131?
Right.
Okay. We might need to look at that whole thing again to make sure it's correct, but. All right. So possession of a machine gun. Laura, can you just lift that and put it in with the rest of those overt act explanations? Thank you. Possession of marijuana. We don't have that, right?
correct. Well, that'll be.
We have it possession with intent to distribute, right?
The marijuana, we do have it up in the overt act.
Okay, well, that will need to go in where the overt acts are explained. So did y'all send that separately? Laura, will you just make sure that one gets grabbed also? We only have marijuana, right? No controlled substances now? I guess we'll still need this for some of the charges that exist, because, right? Yes.
Yes. Although, Your Honor,
yeah.
Could you scroll up?
Mm-hmm. More?
Well, if it's the on behalf of the state must prove the defendant possessed.
Oh, right.
The code you need cocaine. Thank you.
Good eye.
And there it is again in the next paragraph.
Oh, see, now you're taking credit.
Oh, no, we're going to do a word search later.
It's also.
Yep.
That's what happens with cocaine.
It's everywhere.
It's everywhere.
Okay.
Right there, Sue. In the sentence above, Your Honor, if you go back up to equal access, the second line.
Thanks. Okay. We still haven't gotten the verdict form, but.
Did you, Your Honor?
Mm-hmm.
The state did send a verdict.
Oh, I'm sorry. Yes, I know. I mean, we haven't settled on one yet, nor have we reached a point of discussing beyond what we've. Yeah.
I want to make sure.
No, yeah.
And I would really like some time to. I understand that you gave us a heads up on the verdict form, but I'm still going to need time to weigh in on that.
All right, so I think that's everything for this one, other than making sure of that. But now we need to go through, is everything patterned for the other crimes that are only other acts? No? Okay. Why don't we get out of this? And do you want this forwarded again to you so everybody can take a look at things that we might have missed?
Sure. Could we save it under a different title?
I mean, I guess we could do that. Yeah.
I didn't mean that sarcastically, Your Honor.
I know.
Your Honor, this is probably, of course, but the RICO that we worked on as well, instruction.
It's embedded, I think.
Okay.
Yeah, it is in there now. Thanks. Okay, let's see. All right, Laura, I'm just going to let you. Are you going to be the one to share the?
I can, but I.
Which would be easier. Okay. Let's everybody take a minute. What's the date? November what? Thank you. So I'm going to title this November 20th jury charges with RICO, and then Laura, you can send it. Whenever. They don't need that right now.
Well, we'll add, because we'll have to add all this in as well.
Okay. All right. And
So I'm sharing this now.
okay.
So this is what the state sent over earlier. Obviously, I took the title off. But
All right, so what's on the screen now is everything that would cover anything that's a crime in the overt acts.
except there may be a couple we need to add again based
Okay.
on other things, but.
What is this called in the, is this in the jury charges thing? What is it called?
States.
Okay. What a good title.
So, okay.
You know what I'm saying?
Mr. Weinstein just brought up a point to me.
Okay.
With these overt acts, the pattern charges refer to people as defendants, and I don't.
Yes, no, we definitely don't want to say that. So maybe we can just do a global replace of someone, a conspirator.
How about actor?
Person. I definitely.
Person?
A conspirator.
The person.
I
don't want.
I mean, okay, but maybe the person assaulted another person.
Or.
Actor.
The other person.
Actor.
The person. That's just going to get confusing.
Actor.
Perpetrator? Perpetrator. Okay, so do you know how to do a global replace? Okay.
Or maybe.
Alleged
perpetrator, yes.
Okay. All right. So we'll change defendant everywhere in there to alleged perpetrator. And then.
Can I ask why conspirator is not appropriate? Because you have to be either an indicted or unindicted conspirator to make everyone guilty. You can't just be some...
A conspirator, maybe?
Yeah.
And alleged...
Alleged conspirator?
Well, no, because they'd have to actually be a conspirator.
Right, but I'm concerned if Your Honor gives jury instructions saying the conspirator, that is not intentionally, but
no, but it might be saying, hey, they are conspirators, right. And we don't want to do that. That's for them to decide.
Oh, I know that's fair.
Okay, so the perpetrator.
Alleged perpetrator.
The alleged perpetrator, sorry. All right. All right, so there are 2 non-pattern charges: criminal use of an article with an altered identification mark. Can y'all see that on the... I'm not the screen sharer right now, and Ms. Persfield's doing like 7 things at once.
There you go. That's where
Thank you.
I'll finish the rest of it.
Okay. So what are they alleged to have done, whoever had this? I mean, we want to get rid of the language that's not applicable.
Yes, Your
so
Honor. So
It's just concealed.
conceals. When he conceals.
And it's Act 53, Your Honor, in the indictment.
Thanks.
Which Trontavia Stevens, and then it goes on, criminal use of an article with an altered ID by possessing a firearm from which the accused knew the identification mark had been removed for the purpose of concealing and destroying the identity of said article.
Oh, okay. So it's a person commits the offense of whatever that is when he possesses, right? A firearm?
yes, Your Honor.
I'm sorry, say that one more time.
Okay. So when he, and then get rid of from or all the way through possession, and then change it to possesses a firearm. Yeah. Which he knows.
Sure.
All right, and then that's it. Then I think it's fine.
You can take out nameplate, it's serial number, right?
We can, yeah. The manufacturers, what was alleged?
Serial number.
Okay. Serial number.
Yeah, we can try.
Or are there distinguishing?
Yeah.
And it said...
What it alleges is the identification mark.
Correct, Your Honor.
Which, did y'all mean that to be the serial number?
What was the
Are there distinguishing?
I believe, Your Honor.
Let's keep, or any other
I think it's
distinguishing
fine the way it is.
identification.
Okay, and then implied, what is this? Why do we have that? Where did that come from? Number 10.
I include that in all my murder cases. McBurney gives it all the time.
Is that not in our?
Abandoned and malignant heart isn't defined. It's from, obviously it's a non-pattern charge, so I get.
I think we have malice in here, and we say malice can be, it is such, I'm paraphrasing, malice can be formed within an instant or something to that effect in a pattern. I think this is unnecessary because we already discussed malice in the pattern.
The pattern just doesn't define what an abandoned and malignant heart is. This says an abandoned malignant heart may be inferred from the circumstances.
Why do we need to
Hang on.
abandon and malignant heart?
Hang on, y'all. Let me get to the patterns. So it's
For the reason that just Mr. Bott just said.
For malice murder, because the pattern says you may also find it when all the circumstances of the killing show an abandoned and malignant heart, which nobody knows what means, even though there have been case after case after case about what it means.
And maybe we don't need the first
So,
sentence. We just need the abandoned and malignant heart sentence.
So, yeah, part of it's covered. We say you may also find malice where there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. So that first sentence is already covered. Oh, and the second, well, sort of the second sentence. So basically you're looking for a definition of abandoned and malignant heart.
Yeah, the first sentence I just put in there.
Okay.
Where it could be put in the pattern chart.
Is there any definition in the, bench notes of the pattern that define it? All right. I'm not going to do that. Delete that one. Is that everything? Those are all of the charges that are in the...
I just added possession of machine gun.
Okay. Well, all right.
It's out of the other set, but we'll go figure out how we're going to do that.
Possession. Oh.
And then I guess you're going to need to add the codeine and the
Possessed a machine gun.
cocaine back in if it's not there.
Wait, that's... They don't have to have possessed a machine gun during other crimes. They just have to have possessed a machine gun, and then we need to define what a machine gun is. I think we lifted the wrong one.
That's what we have in there.
Okay, well, we need to work on this one. That a perpetrator possessed a machine gun. A machine gun is any... Yes, period. Yeah. I think that covers it. Right? 131, I don't know.
Codeine and cocaine. Is there anything else?
We might need theft.
Theft?
Theft by receiving stolen property, because we have a few theft by receiving stolen gun charges.
Those are overt acts that aren't. Okay. Well, can you quickly grab the pattern for that? Is it theft by receiving stolen property?
Yes,
All right. Is that a separate?
Can we go back? Can we go back to the machine gun when you get a moment, Your Honor?
Okay. Yes. Theft by receiving stolen property is 2.64.80, which Laura, I can grab and drop in here, but will it show up on?
It should.
Okay. I'll just put it right there. Does that show up?
Yeah, it's in right.
Oh, well, you'd have to move it to that part. I put it right above possession of a machine gun. Is it there?
Yeah.
Okay.
Okay.
And obviously we'll need to change defendant again, but.
Can we go back to what you removed in machine gun when you have a moment, Your Honor?
I'm not the one moving it.
Oh, okay.
So yes, but we have to be patient with Ms. Percival.
There you go. Okay.
I believe you removed language about commission of a of a crime. That's in the statute, and it's also the way.
On machine guns?
Yeah, it is. It's A1. It shall be
What's the statute?
It is 1611-160.
Thank you. I've also never done a possession of a machine gun trial.
Well, there you go.
1611-150. Okay. 160.
On the machine gun? I will as soon as we get there. I have to get this added back in.
Yeah, 1611-160. But it is, yes, very good.
Oh, how interesting.
Yeah.
How odd.
I don't know why that is, but I'm not going to question the wisdom of our legislature. Today.
Okay, so it shall be unlawful for any person to possess a machine gun during, okay, so I guess we'll go back and lift them back.
And then in the count, there's a specific list of the offenses.
So it's only alleged that so that would be the two that are left, the possession, during the commission of possession of marijuana with intent. Are other people charged with possession of a machine gun?
Yeah.
All right.
There are. And so there's a list in 62, which probably should be included here, which is criminal street gang activity,
62.
Possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of cocaine.
Possession of a machine gun.
I could read those off, Ms. Persenfeld, if you'd like. Okay.
As it's indicted, it's participation, it's everything that's in 62. Is that what you just said? Okay.
Yes, everything in 62,
All
Your
right,
Honor.
so we can lift that from the indictment.
Thank
Or
you.
Laura can just type it right now. Okay, what else?
We'll need to add back in, Your Honor, possession of methamphetamine with intent to distribute, hydrocodone with intent to distribute.
Hang on just a second. Why are we adding those back in?
Because those are Act 69 and Act 70, they're overt
acts. So are there overt acts that are possession of a machine gun?
Yes. That is.
And those are 69 and 70?
No, I'm sorry. Possession of a machine gun is 188.
So they were alleged to, Kitchens and Williams were alleged to have possessed meth and hydrocodone with intent to distribute at the time that raid occurred?
No, sorry. Two separate conversations, so I should finish.
Okay. So the machine gun one is fine now?
Yes.
And you're saying separately, as offenses that we explain, got you, we need to do possession of meth and possession of hydrocodone with intent to distribute.
And possession of MDMA, which is Act 77.
Okay.
Hang on, real quick. Which ones are intent to distribute and which ones are possession?
All of those are intent to distribute.
Methamphetamine, hydrocodone, and MDMA.
Those are all intent to distribute?
Yes.
Okay. And is there, other than the cocaine, is there anything that's just possession?
No.
Do we still have a simple possession of marijuana as an overt act?
I believe we do.
I don't know, and I know where I'm speaking it was. I don't know if you would need to do MDMA because it's Act 77 and it's just referencing what Mr. Nichols had been previously convicted of to make him guilty of possession of a firearm by a convicted felon.
So we don't need that. Thank you.
Thank you.
So it's MDMA, no.
And the hydrocodone, no.
No. We need hydrocodone.
We do?
Yes.
We do. That's
Oh, sorry. Okay.
Act 70.
Sorry.
And if we don't, I think we added it back, but possession of codeine with intent to distribute.
Yeah.
Yes. I'll try to go back for a double check.
Your Honor, I'm double checking. I'm just control Fing possession in the indictment to make sure I'm not missing
Okay.
anything. And there is Act 49 has possession, simple possession of oxycodone.
Okay, so on the possession, do you want them listed separately? I guess so, yeah.
All right, I think we're getting to the end, but I need a quick break. All right, while we were on the break, I think Ms. Pursfield caught a couple more charges that need to get included that were, I think, maybe drug charges as well. So we'll get those included. And then we will send out to everyone to take yet another look at these jury charges, including all the RICO we just did, the overt act crimes that we are just now including, and then hopefully everything edited correctly as to the rest of the charges. I think when we define the crimes that are just overt acts, they're not counts, that we need to set that off somehow, and I'll just kind of say, hey, you're going to get a list of alleged overt acts, and some of them are crimes. So I'm giving you the definition of those as well. Something like that.
I think that makes sense now.
Okay. All right. So I know the state has provided a jury form that they're going to try to further tailor now that we have a better concept of how we're charging. And I know that was tedious to get through, but I think it was very important that we did it, and it kind of took everybody thinking it through to get to there. So I appreciate that from everybody, and whatever y'all come up with in the way of proposed verdict forms, just forward to Ms. Pursfield. We'll look at all of that. I know y'all need to know when we're going to start the closings. The only things we need, and y'all still need to put those stipulations together. Just pointed out that there are certain overt acts that are alleged to also be an act of, a gang act violation. And we've defined those overt act crimes, and we have sort of defined what a gang act violation is, but when we did that, we only did it with regard to the crimes that were substantive counts of the indictment charges. And there may be there's like an aggravated assault or something like that, and other things.
Yes.
So
there's an attempted murder, there's a conspiracy for murder,
so we're going to need
drug
to
sales.
I think to keep it clean, instead of trying to
still keep it
together,
separate.
Yeah, I think maybe we just
Okay.
the same thing except criminal gang activity. However, we have
For purposes of the overt acts includes. Okay.
Do you have to do that? And I'm just saying, I'm throwing it out because the catch-all says any act of violence, drugs, it lists like the categories. So I mean, an aggravated assault is clearly a violent crime. It's just a suggestion to make it less wordy, but
I agree with Mr. Abadi.
Okay.
I think I do actually, Mr. Abadi. I think that when we're defining, I don't I don't understand the need. I wasn't going to die on that hill, but I don't understand the need to specifically say
these things
are
equate to
gang activity, and that applies to when we defined it earlier and now. I think we can just the problem is the definition of criminal gang activity in the statute is very long, and then it has the catch-all, and then it becomes and then you're making references to different statutes as well. Like, certainly I understand crime of violence, but then there's the catch-all, and then we would have to reference the RICO statute.
And that just gets to be a nightmare. And so when we are doing it for the overt acts, what are y'all saying? Or what are y'all saying that y'all agree to?
I think I liked what Mr. Abate said, but I also think it's going to get cumbersome if we expect them to parse through everything. But so I would just do it the same way we did it in the first part, and just say aggravated. What is it? Aggravated battery? Aggravated assault would constitute, if proven, would constitute criminal gang activity.
That goes on first agreement.
Yeah.
And where do you want that?
Well, I think if we cut and paste from the first part defining criminal gang or gang act, okay, and we put everything, we copied it and pasted it here as well for the charges for the overt acts, except when we have that little explanation of criminal gang activity, instead of putting murder and those other, we just put aggravated assault.
Can I make another suggestion? Your Honor, is your intention to charge on the overt act crimes first or second? Because my thought is, if we were going to charge on the counts first, you can maybe say criminal gang activity as previously defined, and then just put that last paragraph versus restating the entire charge, just saying criminal gang activity also includes this, and this, so that we don't have to say it twice. That may or may not be simpler, but I'm not sure.
Okay.
I think sorry, I'm interjecting, but I think the issue with that is the overt acts have to be with the RICO charges. Or we say something.
Yeah, I mean,
it could be later, but it has to be clear that these are related to, I mean, because the overt act is mentioned in RICO, and so it either needs to get restructured or we somehow refer back to it, but it seems confusing if the overt acts are listed way after, totally away from all the RICO.
Maybe charges for overt acts and parentheses as alleged in count 1 first.
Or if you're doing the overt acts first, you don't have to repeat it the second time when we're talking about the
thinking
charge.
about doing the overt acts first.
I think my ultimate point was I don't think we need to repeat it twice. We can, whichever time we do it, just refer back to.
All right, the gang counts against Mr. Kendrick and Stillwell are 50, 51, and 57, right? So what I could say is, after we define it, for purposes of counts 50, 51, and 57, murder, blah, blah, blah. Murder, possession of marijuana with intent to distribute, possession of a firearm during the commission of a felony constitute criminal gang activity. And then wherever we're doing it for the overt acts, say, for purposes of the overt acts, whatever they are, constitute criminal gang activity. Would that make sense?
Yes, but we have another problem.
Okay.
One of the overt acts is section D of the criminal gang charges. That would be number 182, unless that is out.
Oh, maybe it's out.
I think that's the leadership.
It's out. It's out. Yay. Okay.
Is it out? I doubt it.
Oh, 1 and 2 is out.
Oh, Excellent, okay. I just mean excellent in that it's one less thing we have to deal with.
We said it too.
Okay. All right. Good catch, though, Ms. Persifield.